May
Yes.
it means item 3.
Item 3.
So item may be adjourned today. Any day.
Why?
Except today. The next council will also session.
Why it is IA?
For instance, I was filed to impede the one department,
Complete whom? Complete whom?
the personal department of.
So will implement it. Why should we adjourn? Yes. Next.
I've been asked for take adjournment.
Uh-huh.
I'm not in the case.
Okay. We'll allow the implement. Will not unnecessary adjourn. This matter is pending since long. Yes.
Please take a look.
Yes.
Beg to mention item number 30. Statutory petition. You want
30.
to file on additional application. It is. Use the petition.
There are the learned counsel for the petitioner. Matter can be adjourned and be listed after.
The document item for 27. But the pandemic
Yes.
can be author for the
Why?
engaged council out of it.
You are not engaged counsel.
No, Lord. But engaged New York council is already expert in the month of August. Then
It's a fixed matter. Okay. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 3 weeks.
May I please interrupt?
Yes.
My lord, I beg to mention item number 4. In this case, my lord, I need to file reply. Matter may be
Wait.
highly obliged.
Please take a look. Sachip, I beg to mention item number 21. I am appearing on behalf of Mr. B.T. Kushwani, and there is a bereavement in his family.
Item number
21. Kindly pass over the
taken consent from the other side. You have taken consent from the other side.
no,
Wait, inform or wait for some time. Okay.
may it please your lordship. Lordship, the concept of the other side, I beg to mention item number 10, lordship.
Yes.
Some instruction is to be taken. Can the matter become after 2 weeks, lordship?
Okay. On the prayer of the learned counsel for the we'll wait for some time. We'll just it is 2023. It is in motion still. Let's wait for some time. Now we'll see. Yes.
Your Honor, I didn't receive the copy of the petition. Didn't, uh, the bank authorities doesn't have the copy of the petition. Well,
None appears for the petitioner. You are appearing for?
153, respondent number 153.
None appears for the petitioner on call. However, MS
MD.
MD is present representing the respondents. Full stop. The present petition, the petition is filed claiming arrears of increment to the tune of rupees 20, 2769 58 for the period with effect from June 2001 till 31 October till October 2020. On order dated 1/11/2019 reflects that the the matter was adjourned to enable the learned counsel for the petitioner to file implement petition. Stop. Office note dated 20/12/2023 reflects that no steps has been taken to file such implement petition. Stop. None appears for the petitioner on call today also. Accordingly, the petitions are dismissed for non-proceeding. Yes.
In this case, my lord, I was directed to obtain instruction. I have received the instruction. There was no vacancy of 5% quota in this Tezpur district commissioner.
May I speak your lord? My lord, in the year 1997, my father expired. I was appointed in 1997, and since then I've been working. Initially, my salary was 900. Now it was raised to 24,000. Now I take your lordship the last judgment, page 47, passed by the Honorable High Court. Matter has been finally decided. Now they are acting upon it. 47, please come.
Now, what is the situation as on date?
I'm not getting scale, I'm not getting sell, but only 26 I'm getting.
You are issuing a notice.
Notice
See, here is a case, a different case. He was, may not be in a due process, but he was appointed due to his death of his father.
order.
And he continued in the state. You no, how will you deal with page 49? Page 49.
No, it is absolutely wrong. I have been serving till today.
No. So that's why you are issuing a notice.
In fact, we have prepared the affidavit also.
You file it. Hard
You file it.
SC Business Learned Council for the. Also, Mr. Sutia for
And
GAD. From Fukan for GAD, Mr. Sutia for
I am for 4, my lord.
respondent number 4, and Nayak for 1 and 3. Respondent number 3, and anybody for land revenue? J. Hendik. Yes, J. Hendik. Good stuff. The petitioner. What is your prayer, Mr.
My prayer is, my lord,
Petitioner?
to regularize.
Petitioner. The case of the present petition is filed claiming regular scale of pay. Regular scale of pay. In as much as it is the case of the petitioner that the petitioner has been continuing, has been rendering continuous service
Since
in
6, 8,
a
97.
vacant post of peon since 1990,
6, 8, 97.
from since 1997, and also receiving regular scale of pay. However, subsequent to 1997, he has not been paid his regular scale of pay. Full stop. Issue notice, returnable 4 weeks, except notice to enter extra copies. Like you will file it, affidavit file 2000.
My friend has already prepared it.
Okay, file it. Next.
My lord, I pray for day, fixing the date.
Okay, give a date. Returnable on.
And-
First of. This is item number aggrieved by the failure on the part of the departmental authorities to reimburse medical expenses on account of treatment undergone by the petitioner's husband, the present writ petition is filed. Full stop. Present writ petition is filed. It is the case of the petitioner that issue notice returnable after 4 weeks. Who will appear for whom? Finance. Nayak 2, then
I am for 1, 2, 3, and 5.
1, 2,
3 and 5.
3 and 5. Who is for 4?
Oh, 5 is
5 is woman.
5 and 6, Lordship.
5 and 6. And Chutia?
4. 1, 2, 3, and
Extra copies. All are represented or any
7 also.
7 also. Chutia. Just give us.
1, 2, 3, 4, and 7.
1, 2, 3, 4 and 7 Chutia.
Lordship,
Nayak.
1, 3, 4, and 7.
1, 3,
4, and 7.
3, 4 and 7 Chutia. Then
2.
2 Nayak.
5 and 6.
5 and 6. 4 weeks. Returnable 4 weeks. Steps within all duly represented. Extra copies 5 days.
Obliged.
Okay, just a minute.
Lordship, there is an IA for correction.
Hmm?
There is also an IA, Lordship.
I have for
Correction of the respondent number 1. The designation.
who is respondent number 8?
There is no such.
Personnel department. Is that it?
In my copy,
There is no respondent number 8. Okay. IA 3700. Present application is filed to implement the Commissioner and Secretary to the Government of Assam Personnel Department Dispute Guwahati 781006 as respondent number 8 in the connected petition. Okay. Peruse the readings. This court is of the view that the respondent number 8 is unnecessary for proper adjudication of this matter. Accordingly, the present application stand allowed, and the Commissioner and Secretary to the Government of Assam Personnel Department is Guwahati 781006 be implemented as respondent number 8. Full stop. Okay. Respondent number 8 will be Chutia.
Yes.
Chutia. I extend this for the
Obliged.
history to correct this outside the record.
May I please add?
Yes.
My lord, this matter relating to the my lord pensionary benefit matter.
How can we decide this kind of thing?
My lord, wife is already, my lord, petitioner is already declared to wife of the my lord deceased person. My lord, kindly see page 32.
Okay.
Family court order.
Art. Whom you want to implicate?
My lord, no, my lord,
You want some time, something.
oh, no, my lord, for filing my lord reply matter.
So at no, will issue a notice hard. Counsel for the petitioner. The grievance of the petitioner is that she has been deprived of family pension
Right.
on the date of her husband, and same has been paid to the mother.
Yeah, earlier father,
Uh,
after his
Now
sister,
to the mother of her to the mother of her deceased husband, and by depriving her claim. Issue notice 4 weeks. Who appears for whom? Tell us. 6 weeks.
I'm appearing on behalf of respondents for.
Huh?
I'm appearing on behalf of respondents. Akita.
Home, government of Assam, home, who is appearing for home and police?
Yes, I am.
Respondent number 1, 2, 3, 4. 1, 2, 3, Mr. Sutia. 4, Accountant General. Your name, please.
No, yeah,
4, Director of Pension, Sutia.
Yes, yes.
Sutia, respondent number 5, Sutia. And 6 is Mr. Nayak. And 7, notice both ways. 7 both ways, steps within 5 days. Extra copies to the others.
Highly appreciated.
My lord, on 14/11/2023, the respondent number 2 had asked an order.
Hmm.
Lord, can you deduce the order?
Okay, nothing survives.
Nothing, sir.
Okay.
No cause.
The present petition is filed being aggrieved by an order of transfer slash attachment dated 19/9/2023. Full stop. This court, under its order dated 11/10/2023, state the aforesaid order. Full stop. In the meantime, the petitioner applied for made application seeking voluntary retirement from government service.
My lord, not in the meantime. My prayer was to process my voluntary retirement.
Okay. No. In the meantime, by an order dated 14th of November 2023, the Director of Sports and Youth Welfare Assam has granted the voluntary retirement to the petitioner with effect from 31/12/2023. In that view of the matter, nothing survives in this petition, and accordingly, same stands closed.
Obliged. Please, your lordship. My lord,
Yes.
your lordship, tally previous last order, the education department sought time to seek instruction. Yet to receive the instruction.
They're issuing a notice.
Short notice.
Short notice. Heard Mr. M. Sharma, learned counsel for the petitioner. Also heard Mr. N.J. Khatania, learned pending counsel for the
Secondary education.
Secondary Education Department. Full stop. The grievance of the petitioner is that the petitioner has been deprived of arrears of salary amounting to rupees 2,53,200 despite the proposal being made on 1/6/2022 by the Inspector of School, Dibrugarh District Circle, Dibrugarh. Full stop. Issue notice returnable on give a date. Short notice. Possible, Mr.
Yes, yes.
You have the instruction.
Yes,
on 25th of January 2024. Mr. Khatania accepts notice for all the respondents.
No, my lord, except two.
Accept notice for
The finance. Who is that?
accept notice for
1, 3, and 4.
1, 3, and
1, 3, and 4. Mr. Nayak for respondent number 2. And 2 extra copies. Full stop. On the next returnable date, the Learned Standing Council for the Education Department may either file affidavit or apprise this court why, despite of the proposal being made on 1/6/2022 by the Inspector of School, Dibrugarh District Circle, Dibrugarh, the arrears of salary has not been paid. Extra copies, you give the extra copies.
Please, last time, direct inspection.
Notice will issue. Yep. Who will appear for whom? But Mr. K.D. Sharma. Head counsel for the Oh. The grievance of the petitioner is that the proposal to pay arrears of salary, proposal to arrears of salary has been sent by his employer, that is NC Hills Council, NC Hills Autonomous Council, uh, to the to whom? Finance Department. Finance Department. However, till date, he has not been paid arrears of salary. Is to notice to enterprise. Okay. However, on the accept notice, Mr. Who appears for whom? Hmm? Uh, One is any standing council? Commissioners Governors of Hills Areas Development Department.
Respondent one.
Respondent number one,
A. Chakravarti.
Chakravarti, respondent number one. Mr. Nayak for 2 and 3. 2, 6 and 7. Who are for 3? 3, 5 and 6, Mr. Gogoi, B. Gogoi. And 4, 3, 6 and 4. Any standing council? RM Das. 4 and 7 for RM Das. Okay, 2, so 4 for 4 RM Das. Extra copies, 5 days. On the next returnable date, the concerned department shall apprise this court. Who will apprise this court? Finance? Okay, the finance, Learned Standing Council for the finance department shall apprise this court regarding the status of the proposal sent by the NC Hills Autonomous Council regarding payment of arrear salary to the status of consideration. Give a date. Mr. Nayak, we can dispose it of policy. Either he gets it or if you dispute, will unnecessary dispute should not be kept.
Maybe.
Yes.
Here also I'm paying for some more time.
What is this?
This GPF amount and 1 month salary, my lord.
Why GPF is why not paid GPF?
In fact, it's our mistake. We have not communicated with the department.
Okay, we are having it next Monday.
Yes, ma'am.
Okay. Mr. NJ Khatania, Learned Counsel for the respondent, submits that he may be granted a week's time to obtain the instruction in terms
On
of
8.
in terms of this court order dated 6/11/2023. Accordingly, please this matter on 8. You have it. GPF is his amount,
Yes, yes, ma'am.
not your money. Non-appearance for the petitioner on call. List of the points. Yes,
Make
somebody
it,
wanted some time.
Yes, madam. My lord, the recent judgment of this honorable court. madam.
No, you want some time.
Yes,
Forget
sir.
about the judgment.
Some
Why,
time.
why you want time?
Because, my lord, there is a judgment of this honorable court
Uh,
which goes contrary to my stand, my lord. I have to vote.
what is your stand?
My stand was, my lord, suspension from the day of suspension, my lord. If it is not within, charge is not done within 3 months, I have
It is
to,
from the intimation.
yes, but now it is intimation.
Intimation. When have you given the intimation?
No, my lord, my case is not that, because of this, my lord, I took that from the date of suspension,
Hmm.
so, my lord, sometime maybe.
In the meantime, your period,
Otherwise, my lord, my time would be not
no, your case is not matured.
Yeah.
now.
true, my lord. That is fine. I'll just find out some other.
Better to withdraw and file after some.
That my lord, I'll take it.
Okay. Learned counsel for the petitioner. Press for an is granted. Press for an adjournment. So the prayer is allowed. List after
Immediately after, with you, with
after 2 weeks.
deeply obliged.
Yeah, petitioner, area salary for month.
Kandapar and Mr. Devnath.
For numbers 1, 2, 4, and 5.
1, 2, 4, and 5. 3, Mr. Nayak. The grievance of the petitioner is that he has not been paid monthly salary for the month of March 2007 amounting to rupees 24,902. Full stop. This court sought for instruction under its order dated 6/11/2023. Pursuant to such order, Mr. Devnath, learned standing counsel for the PNRD department, submitted that by a communication dated
8/11/2020.
8/11/2023, the Joint Commissioner, Office of the Commissioner, PNRD Assam, has already submitted a proposal to the government in the PNRD department for sanction of the aforesaid salary, and same is pending for final consideration. Issue notice returnable after 6 weeks. Notice already. Huh? There is no order of 1810. There is only one order 6/11. Which,
The year will be 2017.
2007.
March.
March 2017. Salary for the month of March 2007. 17 legi. Issue notice returnable. 1 month salary you can wait. There is no urgent. In the meantime, Mr. Devnath accept notice on behalf of respondent number
1, 2, 4, and 5.
4 and 5. Nayak, respondent number 3. In the meantime, standing counsel on the returnable letter, the learned standing counsel for the finance department will apprise this court regarding the status of consideration of the PNRD. You will say, oh, sorry. He will go to the PNRD, standing counsel for PNRD will apprise this court regarding the status of consideration of the claim of the. Please take on.
I'm petitioner matter.
Hmm.
This is pensionary benefit in the year 2008 month. Due to not difference of kind of permanent PPP, the concern.
Now, yes, madam, you are representing whom?
Lordship, I'm appearing behalf of K. Gogoi. Lordship, he has received the instructions. So kindly short notice may issue.
Kindly?
Issue the short notice may issue. Lordship.
No,
He's
this is a pension. Let us have it. We are waiting for him. Let him
Lordship,
come.
he is out of station due to some medical reason.
When he will be returned?
by 7th.
We'll keep it on 8, next Monday. It's submitted that Mr. K. Gogoi is indisposed. Accordingly, matter stands adjourned and be listed on 8.
of
Okay.
next month.
You have it, these are pension matters. If possible, we will decide. Yes,
Matter part for that not payment of period salary matter. With effect from 5/11/2020 to May 2020. Last pocket that got a inspection was for.
you are getting the current salary?
Yes.
Okay. The grievance of the petitioner is that his arrears of salary for the period with effect from 5/11/2020 till May 2023 has not been released. Full stop. Issue notice. Returnable. 4 weeks. Mr. N.J. Khataniar, Standing Council for Secondary Education Department. Accept
One.
notice for
1, 3, 4, 5,
1, 3, 4 and 5. Any other?
2, and 6.
2 and 6, Mr. Nayak.
Present.
Extra copies, 5 days. On the next returnable date, Mr. N.J. Khataniar and Standing Council for the Secondary Education.
I can appear for both, man.
Both, Standing Council,
Department of School Education.
Department of School Education shall apprise this court regarding the claim of the petitioner. Claim of the petitioner. Give a date. All these area salary you can give date. Mr. Khataniar, have the instruction.
Yes,
This
sir.
matter should not be kept in. Yes. Yes, Mr. Sheikh.
It is for instruction, madam. I have
Why have you deducted 40 rupees per
40
month
only put
from the pension?
Let me issue notice.
No, why we must know.
notice already issued.
No notice.
Let me issue
It is
short
not a single case notice.
Let me issue short notice. I'll obtain the instruction.
Extra copies I have served, madam.
No notice it is good. Mr. Nayak, you were supposed to obtain the instruction.
I did the court order.
Huh?
28 to 2018, page 11. Certificate directed was to
Where?
page 12 of the So it is made clear that the respondent of construction by arriving at the conclusion as to whether the enhancement A must be to the petitioner because of the fault of the
Okay.
subsequent certificate comes to this object. Video was that certificate that it is only one page from one more page in here. The reason for deduction will be that way.
Where is your PPO?
Last page on page 14.
Uh-huh.
This is the first page.
Uh-huh. Uh-huh.
One more page will have been there.
Case 15 is there.
15 is there.
It might
It is pensioners which is draw his pension through an authorization on 2020.
15.
Nothing is there regarding recovery.
that
No, there is a one page, your one page is
Page 15, madam.
page 15.
I'll supply.
not it. Because type of. Okay, this order contains one more page.
Okay, you say that page annexer 2.
Annexer 2 not.
Annexer to that treasury officer.
Yes.
To the treasury officer.
Yes. This could have one
Okay,
more.
that you want to say that it will
Yes, ma'am.
have another copy. Page 1.
This is one page only.
Huh.
One more page to that there.
What will that reflect?
not there the reason deduction. And it has been communicated to the petitioner as it appears on
Uh,
memo.
Tonkeshwar Gogoi, retired headmaster, to receive payment. If,
Lord,
however, he sees.
What is available with me, my lord, that I have.
Not we can also
Okay.
it issued by the
What is your total pension? Total amount?
Total amount,
Sanction?
my lord,
9640.
yes,
So now they are paying 9,000.
Only 40 rupees.
Huh?
there
40 rupees. Ma'am.
probably
40 rupees they are deducting.
Yes.
40 rupees deduct. But
9,000 you are getting.
My claim is this, my lord, they illegally deducted.
No, that's maybe 1 rupee, maybe that may be illegal. So we'll examine this.
Yes, sir.
otherwise he is getting
That is Mr. Sheikh, learned MSc, for the petitioner. Grievance of the petitioner is that an amount of rupees 40 per month is deducted from the pension of the petitioner. Issue notice returnable on evaded 5th of February 2024.
Anything from 1,
2, 3 and 6.
3 and 6.
Mr. Khataniar 1, 2, 3, 6. You have for 7 and Nayak for respondent number. Respondent number 7.
Yeah.
And anybody? 1, 2, 3, 6 and 7. 4 is a minute. Extra copies do you need? 40 rupees he has already
Given.
already he has given. But notice when will issuing notice will say that extra copies.
Unless I am to give extra copies again.
Keep one copy.
Yes.
Otherwise that will delay it as well. Yes.
the matter pertains to non-payment of kindly schedule the order dated 21/12/2023.
Well, issue notice. Substantial, you have been reinstated.
No man.
Huh?
No man. And
Eh.
a contempt case is pending regarding that. The petitioner allowed suspension order was set aside, but still not been a contempt case is pending. Schedule paragraph 5 and
You are still under suspension.
Yes.
Or suspension order is set aside.
suspension order set aside by the Honorable Court, still not reinstated, and contempt case is pending regarding willful and deliberate violation. And no substitution allowed from pilot date of suspension, that is pilot 11/10/20.
Yes.
My lord, that one instruction I have received.
The last occasion is special also will kindly pay the order dated 21/12/20.
I thought that you were reinstated. That's why we will. Paragraph 2.
This instruction was placed before the Honorable Court on 21/12/2023. Will kindly peruse that order.
What is 16/11/2022? No, this is something different. you have made sanction on 5th of August.
Lordship.
Now why he is not getting?
My lord, it is, my lord, the last para it is given some necessary, my lord, certificate he have to produce, Lordship. He has to submit it.
Have you communicated this order to him?
My lord, I have communicated. Deputy Commissioner Sunil Kumar, 21/12/2023.
Have you given this 5th of August 2022 to him that you will have to give me a certificate under
Will kindly below page 19 and 20 of the list. Already given. Unnecessary they are getting cut. Page 19 and 20 of the list.
page?
19 and 20. 19 is a forwarding letter, 20 is a 30. As required under FR 53. 19 is a forwarding letter, certificate is at page 50. Way back on 111 page 50. Is required under FR 53.
My lord,
Let it be, my lord, and next week, my lord. I have received a number of receipt, but he is not overhead
Tomorrow
tomorrow.
our deputy commissioner will be here. Pursuant to this court's order dated 21/12/2023, Mr. J. Hendick, Learned Counsel for the petitioner.
no, I'm for
Sorry,
one and two.
respondent number 1.
1 and 2, Lord.
Respondent number 1 and 2 has produced a communication dated 5th of August 2022, which reflects that the subsistence amount, subsistence allowance has been sanctioned by the Revenue and DM Department, subject to and it was provided in the aforesaid communication that subject to production of necessary certificate as required under FR 53 within bracket 2 of the FRs and SRs, fundamental goods and subsidiary goods. FRs and SRs, the payment should be made. Accordingly, Mr. Hendrick submits that maybe for non-furnishing of the certificate payment. Full stop. Countering such argument, Mr. J. Patwari submits that such certificate was issued when
111 forwarding letter is of 111.
such certificate was issued on 1/11/2022
And it was received below necessary.
and same was received on the same date. And in spite of such submission, the subsistence allowance has not been paid. It is the further case of Mr. Patwari that even after the suspension order has been set aside by this court under its order dated 17/3/2023 passed in WPC 3730/2022, the petitioner has neither been reinstated nor the subsistence allowance has been paid till date. It is seen that this court under its order dated 17/3/2023 passed in WPC 3730/2022 directed the respondent number 3 to forthwith reinstate the petitioner in service. Full stop. Full stop. Be that as it may, the petitioner is entitled for subsistence allowance during this period of suspension. Full stop. The instruction dated 5th of August 2022 also reveals that such payment has duly been sanctioned. And it is also seen from the annexer 3 that petitioner has submitted the certificate in terms of FR 53 within bracket 2. First of- In the aforesaid background, the respondent authorities shall invariably apprise this court the reason for non-grant of subsistence allowance to the petitioner by the next ethics. List this matter on 8.
Lordship, that one, the deputy commissioner is not party. However, I have sent a letter to the deputy commissioner. For instance,
That letter,
Who put him such? Who is his employer?
the deputy
deputy
commissioner.
commissioner. I have sent it letter.
Well, he is the under the deputy commissioner. He is a circle officer serving as a circle. My lord, that one letter was given, my lord, to the joint secretary revenue to the deputy commissioner. And lordship, last para it is
No, Mr. Handik and Mr. Chutia. Whether what has happened to him, whether he is suspended. He has suspended, there is no doubt on that.
it is true.
Forget about his reinstatement.
That is true.
No issue.
No,
For us,
no.
this writ petition, no issue. He has been reinstated or not reinstated. Is he not entitled for subsistence allowance?
Definitely, my lordship, he is
If he is allowed, and if he has not been paid the subsistence allowance, whether it is deputy commissioner or employer, whoever, it is not our concern.
I will
Our
appeal.
concern is that you will have to pay the subsistence allowance,
Yes.
and you have not, if you have not paid,
Yes, sir.
and if we decide to give some interest, then the concerned person will have to pay it from his salary.
Lordship, my lord, the
Whosoever.
revenue department already been directed our deputy commissioner to take necessary action to, my lord, given the substance along to the petitioner. He
Mr.
requested in the
Sutia,
outlet.
Yes, sir.
You
By-
just
by
have the
8, my
instruction.
lord.
Please this matter on 8.
Can I take back the, my lord, that instruction?
Yes, yes. You can. Yes, sir.
Lordship, here petitioner has been stopped from on some legal grounds. Lordship, the fact is that petitioner, Lordship, he was retired from on Lordship, prematurely retired from service from Assam Rifles. After premature retirement, he was given granted pension. But challenging that premature retirement to be illegal, the petitioner approached the Honorable Court. And Honorable Court, Lordship, was the illegal order of Lordship premature retirement. And Lordship,
Where it was?
yes, it was quashed
By?
by the Honorable Singleton.
Okay, then.
Then thereafter, Lordship, the part Honorable Singleton observed that since the petitioner has crossed the age limit of superannuation during the pendency of this petition, so the petition become infractional. So that order of Lordship premature retirement was Lordship quashed.
Where is
So,
that?
Lordship,
Where is that?
that order? This thing is clear from page 40. Lordship.
Now, what happened in the division bench?
In the division bench, Lordship, the division bench has allowed the petitioner's prayer that he will be entitled for superannuation pension, Lordship. Lordship, but the period he was not in service, that should not be counted. So now the in compliance of the Honorable Court's order, Lordship, Lordship, they have issued the superannuation pension, order of superannuation pension. But they are now asking the petitioner to refund the amount, that retired benefit, etc., that he has received. And thereafter they will issue that superannuation.
And your case is that you deduct from my superannuation pension.
Yes, Lordship. Yeah, now it's not possible for
Lordship, notice me.
You do not earn any stay.
Lordship, that pension,
Anyway.
that because retail pension may be granted, Lordship. But this will cause again some confusion. So a court date may be given.
Art Mr. Tabita, Learned Council for the Petition. And you are, madam?
And then Sharma, I'm appearing on behalf of K. Gupta.
Ellen Sharma, appearing on behalf of K. Gupta. The petitioner is aggrieved by. Where is that communication?
Page 46.
Aggrieved by communication dated 9th of June 2023 issued by the issued by respondent number
Respondent number three lot,
issued by respondent number
three lot.
3, whereby the petitioner was asked to deposit
Lot.
the amount already paid against leave encashment, gratuity, and commutation, and retiring pension to retiring pension so as to pay him superannuation pension.
Sure.
Superannuation. Issue notice returnable on
Short check because pension has been stopped. PPO has been cancelled. They will issue the new PPO once we deposit that
29th of January.
20.
29th of January 2020.
In the meantime, that retired pension may be given continue because retired pension has also been stopped. They are saying that I have to first refund those.
So
Then
therefore, we'll have the instruction.
Sure.
Okay. Not estimate. Next, if you take over, learn it, CGC shall apprise this court whether to recover the amount already paid to the petitioner, paid to petitioner can be deducted in installment from
For-
superannuation pension instead of seeking refund of the entire payment earlier made.
Yeah.
Full stop. This is your case?
Yeah.
Yes. List this matter on no notice. It will be in the motion stage. When?
after the
No, it's still after you give a date after 24th of January. You have that instruction. Whether you deduct it for a percentage,
yes, sir.
then you adjust it. How a
Then we
pensioner will refund from where?
Definitely adjust.
All has gone to dal, rice, and roti.
They have admitted also issued order also superannuation pension has already issued. Obliged.
Like,
Here, notice order annex of 15 page 133. Notice directed to grant tax book to approve it, the entire amount. But the
Where is that?
when we come to page 154 notice. Para 25. Under the circumstances, if there is no denial by the board with respect of the medical treatment undergone by the petitioner, says has been it is directed that the board will examine the matter, and after due verification of the claims made by the petitioner for medical reimbursement of expenses incurred for medical treatment of the petitioner's death husband, the board will grant as to approve it if required. And thereafter reimburse the medical expenses incurred in respect of the treatment, including surgery undergone by the late husband of the petitioner. That was the by of approach of the Sabha authority. Sabha authority get what order.
We understand. But can we determine whether anyway we are issuing a notice? You have been paid an amount of rupees 3 lakh.
3 lakhs.
You claim
Rupees 7 lakh was
You-
expenditure.
expenditure. Now,
It has already been submitted. Sir.
we understand. But if they say that you are not entitled, can a report decide that you are entitled?
But if as per Sabha health regulation, full reimbursement is provided.
Understand full regulation. Anyway, we are issuing a notice. The petitioner is aggrieved by the decision of the SEBA in non-granting the entire amount of rupees
7 lakhs.
7 lakhs against medical reimbursement in as much as pursuant to this court's order dated 22/6/2022 passed in WPC 1481/2022, the petitioner has been paid an amount of rupees 3 3 lakhs by the communication dated 24/2/2023, which is impugned in the present petition. Issue notice returnable on given date February, after 4 weeks. Given date after 8th of February 2024. You accept notice for all the respondents?
No, my lord, only respondent number 3, my paper.
Who are the other respondents?
Secondary educator, so we have formal participation.
Okay, Mr. Khataniar accepts notice on behalf of respondent number 1 and 2, and Mr. D.K. Roy accepts notice on behalf of respondent number 3. Extra copies 5 days. Yes,
In this case, my lord, the petitioner being an assistant teacher, my lord, applied for nearby transfer because of the ailing father. As per notification,
where is that?
an application number, my lord, I have given online application number, page 5, my lord.
Mm.
The last application number, INTRA E001-02697, my. In reference to that, my lord, a medical board examined the claim of the petitioner's parent, my lord, and thereby issued transfer order.
Mm.
My lord, transfer
Where
order,
do you get all this?
my lord. Transfer order is page 17, my lord.
Page 17.
Yes, transfer order.
Yes.
My lord, here what happened, my lord, in the middle, presently working, matlab he was in this place, he applied because it is about 60 to 70 kilometers away from home. Thereafter, they have transferred me here, another school.
Where is the provision under this act, new provision, transfer posting act? How to consider?
My lord, in this the page.
Yes, Mr. Khatana, suppose you, is there any criteria for the family? I am not been.
Where ailing parents, my lord, there is a notification passed in 25/8/2020.
Okay, in terms of that notifications, that can be a ground for transfer.
Transfer, nearby transfer.
You made an application on that.
Yes.
Now,
What happened? They have
transferred you, but same thing, there is no change in situation.
no changing.
Rather, it's a hilly area.
Hilly area, my lord. Again, difficulty to.
Now, where are you?
I am in Bilaipur 1.
No,
New
whether you,
he is new.
I have joined, my lord.
he has joined, he's a gentleman, he has joined. You have the instruction.
Or my lord, he submitted representation. my lord.
Representation, that may be also.
That may be directly issued to dispose of that.
Okay. Hard Mr. AI Chaudhary, Learned Counsel for the petitioner. Also heard Mr. N.J. Khatania, Learned Counsel representing
1, 2, then 6 and 7.
1, 2, 6, and 7.
I'm for the 5.
Bora for respondent number 5. Who is for 6? Mr. Chutia. Or okay. Saikia for 4.
Okay.
Full stop. The present petition is taken for final disposal as proposed and agreed by the Learned Counsel for the petitioner, at the motion stage. Full stop. The grievance of the petitioner is that pursuant to an office memorandum dated 25/8/2022, which provides transfer on the ground of ailment of transfer of a government servant on the ground of ailment of parents, the petition was transferred from
Uttar Damsera VLP
Uttar Damsera VLP
to 154 number Bilailpur Government Junior Basic School. Page 7.
154 number Bilaipur Government Junior Basic School.
Yes, ma'am.
Transferred to that school. Page 70. Page 7. However, such order, according to the petitioner, shall not give any benefit of the memorandum dated 25/8/2022. Rather, same is more more inconvenient to the petitioner. It is the case of the petitioner that due to his ailing parents, he made an application before the concerned authorities in terms of office memorandum dated 25/8/2022, seeking transfer to a nearby place of his residence, that is nearby residence at what is your residence? In residence at Hailakandi. Inasmuch as his place of posting at earlier place of posting, at Uttar Damsera VLP is around 70 kilometers away from his residence, which has created a inconvenience for him to look after his ailing parents. However, though the respondent authority has positively considered his claim and issued the transfer order dated 21st of October 2023, transferring him to 154 number Bilaipur Government Junior Basic School. However, the said school is also around 70 kilometers away from his residence, and it is a hilly area. Therefore, the problem that he has been facing continued. According to him, as the order has been issued considering his claim, he has joined. However, he has filed a representation before the respondent authorities, which is annexed with the writ petition as Annexer 90 as
Five.
Annexer 5. Annexer 5, seeking praying for reconsideration of the transfer order dated 21/10/2023. 21/2023. It's a NJ Khatania learned standing counsel for the department submits that the government has issued the office memorandum dated 25/8/2022 so as to enable the government servant to balance between their work and to look after their ailing parents. And accordingly, the transfer order has been issued. However, if the petitioner has still some grievances and he has filed a representation, the department shall, being a model employer, shall definitely consider such representation.
But
Accordingly,
he has submitted representative to the Deputy Inspector of Schools. So he may file a fresh
Okay.
representative to the Director of Elementary.
however, he submits that fresh representation may be directed to be filed before the
Director of Elementary.
Director of Elementary Education so that the matter can be taken up for consideration. Accordingly, Mr. Hatania submits that this writ petition can be disposed of with a direction to the respondent, Director of Elementary Education, Assam, to consider such claim of the petitioner and decide the same in terms of office memorandum dated 25/8/2022. Taking note of all relevant factors. The learned counsel for the petitioner also agreeable to such course of action. Accordingly, in view of the aforesaid consensus, the present petition is disposed of with the following date. The petitioner shall file a representation before the Director of Elementary Education highlighting his grievances within a period of 10 days from today before the following. And on receipt of such application, the Director of Elementary Education shall consider the same and dispose of the same within a period of 1 month thereafter. 1 month thereafter, taking note of relevant fact as well as the mandate of office memorandum dated 25/8/2022.
Obliged.
If you
Obliged.
proceed, observation, the present petition
May I speak?
Yes.
My lord, matter related to the modified acute career progression scheme. Benefit was denied to the petitioner who retired on 31/3/22.
Are you getting pension?
Yes.
Okay,
Not-
we'll issue a notice at this stage. In the meantime, we'll examine.
Look,
Uh, but the grievance of the petitioner is that he has been deprived of benefit of financial upgradation. Deprived of the benefit of second and third financial upgradation during his
okay.
service.
He had got his service benefit, but the entitled grade pay was 24.
Okay. The grievance of the petitioner, who is a retired employee, has approached this court with a grievance that the financial benefit of financial upgradation
Under modified
granted
acute.
granted to him during his service career has been wrongly calculated.
Yeah.
And in the process he was deprived of the actual benefit. First of all, issue notice returnable after 4 weeks.
Okay.
Mr. S.S. Roy, access notice for all the respondents.
Okay.
All the respondents. Extra copies 5.
Yes, fix on 1st February.
You will not fix it. You are getting the pension. You are giving preference to the other. This is a bounty. May not be bounty, but if you will get it, if you will get it.
Yes, Mr.
Yes.
But as per logical court order, my lord, 21/12/2023, my lord, the case has not been taken upon the respondent number 6, 7, and 8, my lord. But earlier it was taken steps, but we are proper catches we have not collected. My lord. That is why I pray before your lordship, my lord, paper uplift may be.
Okay. The learned counsel, pursuant to order dated 21/12/2020, learned counsel for the petitioner submits that those steps upon respondent number 6, 7, and 8 were taken. However, same could not be served upon the said respondent. Accordingly, he prays that the petitioner may be permitted to take steps for issuance of notice upon the said respondent number 6, 7, and 8 to substituted mode and by way of paper publication. Prayer is allowed. What are their residences? Where they are from?
As per our service record, should be at Pandu. We have the address of Pandu only. There is no house number.
Okay.
Pandu, Guwahati
Okay.
12. New colony, Pandu, Guwahati 12 is the address.
The issue notice to respondent number 6, 7, and 8, returnable on after 6 weeks. Give a March, first week of March. 4th of March 2024. The petitioner is to take steps for issuance of notice upon the aforesaid respondent number 6, 7, and 8 who are resident of Maligaon, Guwahati, through paper publication in daily English newspaper, in Assam Tribune, full stop, and thereafter file it with the annexing the original copy. Okay. Mr. Gupta, A.K. Gupta, learned counsel for the petitioner, submits that he has instruction from his client not to pursue this matter. according in view of such submission, the present petition stand closed. Interim order passed on 29/12/2021 stands vacant. Is this why this is listed in the other column?
My lord, they have filed the amendment petition just
Hmm.
before the vacation, my lord.
IA was allowed.
I was,
Now, where is amended writ petition is being given?
yes, I have been served with the copy just before the.
You have been served.
Yes.
Where is office note? Okay, pursuant to this court order dated 12/12/2020, of this court order dated 24/11/2023, the learned counsel for the petitioner has submitted the amended writ petition, and same is also flagged tagged in the writ petition in the text in the record as flag white. The learned counsel representing the respondent has also submitted that
4, 5, and 6.
respondent number 4, 5, and 6 has submitted that copies has also been served upon. In view of the aforesaid registry to correct the record and by placing the amended writ petition on record. Any rule issued or what?
No, my. Petitioner was removed from service while the school was in Freshers stage.
No, now it should come in the admissions column.
Yes.
Okay. List this method in the admission column after.
Okay.
Yes, what happened?
Transferred your lordship.
Hmm.
But today it has come for your lordship for service on respondent number
3. Yes.
him to be served your lordship. And otherwise your lordship, a matter related to his prayer for consideration of transfer for better to Jorhat. There are certain orders passed by the court your lordship. And by those orders, your lordship,
Yes, Mr. Khataniar. Where is Khataniar?
38.
It is pending.
That's it.
Wait for some time.
Lord.
If somebody can call Mr. Khataniar,
Lord.
we'll fix a date
Lord.
and have the instruction. Or we fix it in admission, they will come.
Lord.
Okay.
Your lordship.
In view of office note dated 3/10/2023, the matter is ready as regards her. Accordingly, list this matter in the admission column on 19th of January 2024. In the meantime, the learned standing council for the just inform him. Learned standing council for respondent number 1 and 2. Mr. Khataniar, 1 and 2 shall obtain instruction in terms of this court's order dated 25/4/2020. You just inform him for the future.
I will also.
Allow lordship and I dispose of Petitioner is allowed to sign the register, Lordship, and they allowed it IA. For the
The learned counsel for the applicant submits that the petitioner has been reinstated on when?
Lordship, release order recall, Lordship, and
Where is that? Submits that nothing survives to be adjudicated in the IA. Accordingly, stands closed. What you say?
Lordship, IA is allowed, Lordship, petitioner is allowed to sign the register.
So therefore, nothing survives in the,
Lordship,
that is what we say.
Lordship.
That nothing survives to be adjudicated in the IA as her grievance raised in the as her or his his grievance raised in the IA has already been redressed. Okay. Accordingly, IA stands closed. Okay. In the main case of Lipa, the respondents are given 3 weeks time to file affidavit in opposition. No, your case, madam, read petition.
Lordship, we have filed this additional affidavit.
Okay, so we are saying that respondents are given to file their affidavit file. Okay.
Lordship,
Read petition. List this method in the admission column after due vacation. In the meantime, interim order passed earlier self.
we have filed for finance department.
What is the issue in the read petition?
Pensionary benefit, matter pertaining to pensionary benefit of the pension matter. And it's from 2019. Initially, I was appointed as ad hoc petitioner regular sanction post. From time to time, I was transferred in the my ad hoc appointment was extended until further order.
Present application is filed by the read petitioner for implement of finance department as party respondent number
5 by the
party respondent 5. Full stop. The connected read petition in WPC 5272/2022 is filed seeking a direction to regularize the seeking a direction to the respondent authorities to accord ex facto regularization of the petitioner in her substantive post of assistant teacher under the elementary education department, and with a further prayer to direct the respondent to finalize and release the pension to the petitioner. Considering the nature of grievance and claim, this court is also of the view that finance department may be a necessary party for proper adjudication of the connected petition. Accordingly, the IA stands allowed, and IA stands allowed the Commissioner and Secretary to the Government of Assam Finance Department, Dispur, Guwahati 6, be arrayed as respondent number 5. Full stop. Respondent number 5. Olga? In view of the order passed in IA 37 IA 3781/2020 3. Register, issue a notice to the newly implemented respondent number 5. Full stop. Mr. Nayak accepts notice on behalf of the respondent number 5. Extra copies of the writ petition be furnished to Mr. Nayak. Highest and basic to correct the cost item.
Lordship, I'm yet to receive the instruction, pay for 4 weeks for the time to file our reply. Lordship.
Here also takes time.
No, on the must, only motion date.
This is the second time.
This is what is the
She's
item
getting,
number?
she's getting the pension otherwise.
14.
Item number?
41.
Why retapil file has come? Okay, writ petition 4562.
4562.
Earlier also they have the.
What is the issue here?
She's getting regular pension.
Regarding,
He was on
regarding
some,
non-payment of non-payment of
the dismissal has been set aside, so once
page
back.
67, your lordship. Page
Tell us.
Right.
We are not hearing them yet. Tell us.
Non-payment of pensionary benefits. Your lordship.
You are not getting pension.
Pension given, but as per direction, your lordship, there are one period payment is left. Your lordship will find page 67. Dated 4/5/2000 till 19/8/2004. Your lordship. Page 67. That is para 23. Pension paid, but and the cost also paid, but that period not paid.
Okay. Mr. B. Chakraborty, learned CGC. Praise for
3 weeks.
but you file it.
No.
She's getting what you should settle all this.
Right.
Praise for and is granted 3 weeks time to file affidavit. Affidavit or apprise this court to file affidavit. To file affidavit.
We file our reply.
To file affidavit. Okay, we'll see on the list this matter on date pension 29th of February. This is item number 41. Huh?
Lordship, I'm not pressing this matter.
Learned counsel for the petitioner on instruction from his client submits that the petitioner must withdraw this application. Accordingly, the writ petition has closed on withdrawal.
Hello.
Yes, Mr. Das.
My lord, in fact, they violated the earlier order of the court and passed this taking order, not in tune with the order passed by the court. My lord, the court's order is at page 59. This was the order passed, my lord, on earlier
59.
page 59.
Okay.
Relevant is at page 61. And
61.
yes. Well, I'll take your lordship to page 63, paragraph 7. I'll read this. In view of the legal fiction under section 16(5) of the RTI Act, wherein it is a statutory provision that the salaries and allowances payable and the other terms and conditions of service of the State Information Commissioner shall be same as that of the Chief Secretaries of the State. The stand of the respondent that as the two writ petitioners have neither served as Chief Secretaries nor in the rank equivalent to Chief Secretaries, they would be disentitled to the benefits of salaries and allowances.
You were information commissioner.
Yes.
Now
were-
they say that you are not entitled equivalent with chief secretary.
No, the rank is on the
Okay, now this court has said that by legal fiction,
he is entitled.
He
He
is entitled.
cannot deny that because he is not the chief secretary. And ultimately, they passed his speaking order. They were, he is an accountant general earlier, and thereafter he was appointed as chief, the information commission. Then they passed a speaking order. Speaking order held, my lord, something different, my lord, on the basis of the order passed by the, my lord, on the basis of the case filed in uh, in in the bench of Arunachal Pradesh, where, my lord, the case was regarding seeking of benefit of pension by the State Information Commissioner to that of the State Chief Information Commissioner. That's a totally different case. No way connected with the matter involved in this case.
Where is that? Where is that?
Page 65.
Why this matter is listed in the order?
No, Lordship, on the last occasion, notice has been issued, Your Lordship. So, Your Lordship, there are two things, Your Lordship. Firstly, in this case, this matter has been sent to the learned advocate general for his opinion in this case, Your Lordship. So, Lordship, we are taking some time to finalize the paragraph comment and file our
So
reply.
apparently, as Mr. Das has said, this judgment says that by virtue of legal fiction under section 16(5), they would also be entitled as statutorily provided, meaning thereby service is there not in the they would be disentitled. That stand has been rejected.
Yes,
That
stand has been
That has been rejected.
Yes.
Okay, what do you want to do?
We need some time to file the affidavit, Your Lordship.
Service is complete.
No, Lordship, respond number 2, Your Lordship, is para 13 of the first order, Your Lordship. Respond number 2.
Commissioner is not a
Necessary party.
not necessary.
Because it will be decided by the state, is that it?
Otherwise, in notice, steps that were supposed to be taken by registered post, Your Lordship. If that
Second,
is the case,
these persons they have retired long time back. They are just denied the benefit of the provisions of the
Okay.
RTA.
You say, Mr. Das, that we should delete the respondent.
No, they are not necessary.
No, I will not say. You say because there is a office note on 1810. Steps, you have not taken steps for us.
They are not deleted.
Okay, Mr. Hart, Mr. B.D. Das, Planet Senior Counsel. Mr. B.D. Das, Planet Senior Counsel submits that the respondent number 2 is not necessary for adjudication of the present petition inasmuch as an order passed by the Commissioner and Secretary to the Government of Assam, administrative reforms, training and pension, administrative reform, training, pension, and public grievances department is impugned in the present petition, and the legality and the validity of the said order is to be decided in the present petition. Accordingly, it submits that the respondent number 2 may be deleted from the area of parties. Without entering into the merit of the contention, the name of the respondent number 2 is deleted. At the risk of the petition. Accordingly, the matter is ready as regards service. Please this matter in the admission column on
3 weeks time, since just to go thereafter.
give a date.
The date may be given.
That's why we are seeing a date. Give a consensus date. You also have, instead of adjourning on date, next date.
So that
After
it can be taken up a second down.
that is fine. Whatever happens, we'll see.
Question is,
Possible 2nd of February? 2nd of February.
I've
In the
given the
meantime, all
judgment
vacations are also.
Not.
2nd of
second week,
February.
2nd February.
Okay.
Petition, mostly at the motion stage. You have not taken steps for implement. You will not appear. Why should we adjourn it? So what?
The client would like to continue
We'll see. But you bring the other side.
Only it will
Oh, we know, but the other side will inform her client
Right.
that this has been dismissed. Inform, bring her. Then only. Or if I will have to might have to file a restoration. You bring her at
Yes.
2 or
at 2 minutes.
or tomorrow at 10:30.
Oh, my lord, notice was sorry.
But somebody appeared. End day.
Tomorrow at
We'll see. We'll see. We'll see. You just keep that back with her. Okay. Why this contempt in
My
series?
lord, only rupees 900 per month was directed to be paid, Lockheed.
Yes,
My lord,
Gogol. What are you doing?
2017.
That amount of rupees 900 is my lord, total is my lord, it is 62 crore.
Understand? I dealt with
No,
this.
no, yes. My lord,
Now what is the stage?
Yes, my lord, they have now again submitted a proposal of 62 crores to the finance.
How we know that? That up to that we know.
That is, my lord, so I pray Lord, may take up on Wednesday, my lord. Let me have today it has come suddenly, my lord.
Because I think I have passed some order.
Yes, yes.
You Lordship passed order.
5/6/2023.
Yes, sir. Now that is E. Borua, my lord, that passed, my lord, the
3/5. Okay,
detailed order.
we know. When?
On Wednesday next time.
The matter stands adjourned.
10.
On the prayer of Mr. Gogoi and be listed on
10 1.
10.
Problem.
Like,
On the said date, Mr. Gogoi shall apprise his court regarding status of compliance
Right.
of the order. Uh-huh. Is it necessary?
like,
None appears for the petitioner on call. None did represent the petitioner on 7/2/2022 and on 18/10/2022. Accordingly, writ petition stands dismissed for non-proceeding. Mr. Khatonia, there are some methods Mr. Pothakur
Yes, yes.
appeared. You were supposed to bring some instruction.
On I think it speaks on 19. I look. Here, my lord, I have received some instruction. It's under the consideration of the department manager. In fact, the matter was placed to the finance department. The finance department raised some query, so it is referred back to the DSC. DSC now put some query from the IS Nagaon and IS Sibsagar. This is regarding the fixed pay of graduate teachers. So, my lord,
The grievance of the petitioner. The grievance of the petitioner is non-payment of regular salary of rupees 15,500
500.
subsequently regular pay.
and the subsequent regular pay scale. Full stop. Mr. N.J. Khataniar, learned counsel for the petitioner,
Respondent, my lord.
respondent, submits on instruction. Mr. N.J. Khataniar, learned standing counsel for the education department, on instruction, submits that the proposal for payment of regular scale of pay to the petitioner has been returned back by the finance department, raising some queries, and those queries shall be redressed and the proposal shall be resubmitted before the finance department within a period of
Not one month.
within a period of a month.
It may be fixed.
Okay, within a period of a month. In view of such submission, let this matter be listed on give a date after 2 months. So that finance can do something. Okay?
It-
5th of March 2024. On which date Mr. Khataniar shall apprise this court regarding the status of the proposal. Status of the proposal for payment of regular scales of pay.
If not,
List according. Yes, Mr. Ali. What is the issue here?
Here, my lord, the issue, my lord, regarding, my lord, recovery of excess amount, my lord.
Traffic masses. Then
Pension has been sanctioned, my lord, in 2020. But it has not been released. I filed representation, my lord, and after, my lord, about, my lord, 1 year, my lord, they have issued the notice for recovery of excess amount.
okay, now recovery state.
Statement.
Now what is the state?
Nothing, my lord. They have not paid any penny.
Recovery pension is also not.
Neither pension, nor gratuity, nor any benefit.
Okay,
my lord.
affidavit file.
But we have filed the
Oh,
affidavit, they have
affidavit.
filed the reply.
Okay, so proceed.
Well, they, yes.
Yes, Mr. Ali, proceed. Let us.
No.
We'll go for final disclosure.
Yes, sir. But if considering the matter, the actual date of birth of the petitioner as per record we have found is 1/7/1954.
Hmm.
1/7/1954.
Hmm.
Accordingly, his date of retirement is 31/7/2014.
31/7
2014.
2014.
14. That is the date of retirement mentioned in the order which my learned friend is relying
Hmm.
at page number 35.
Hmm.
The date of retirement is
Now,
31/7
this is excess dwell for what? For extension of service.
for stay
Overstay.
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 Overstay. That is what I am going to submit. Well, he overstayed till 24/1/2020.
24/1/2020.
On this date, well, he was released from.
Okay.
Well, he has already enjoyed this. So, well, for that period, he will not get pension.
Will not get pension.
The pension will be calculated
On
on
31/7/2014.
2020. It will be calculated and will be paid. Will be released with effect from 25/1/2020.
Yes. See, if you have stayed beyond
Yes.
the period until and unless certain specific proof or something that he has manipulated or after a proceeding you have found it, you cannot make a recovery. That part is gone. Now, so far relating to determination of pension, his pension should be determined in terms from the date who he actually ought to have retired.
Actual date of retirement.
So that's all.
That's
You do that.
That's all.
Why you need a judgment for us?
No. Malat, the petitioner is praying before your lordship for release of the amount as per 6/8/2020. In that case, he will be getting pension from that date.
No,
and
no, no.
already he has
Mr. Ali
enjoyed
will
this-
not get pension from
I am
the.
not claiming, my lord. They have.
That may be clarified and disclosed.
They have sanctioned the pension.
That is the ultimate thing. Malat. If
That is the
yes, that
Recovery
that I-
will there shall be no recovery.
Yes.
And your pensions will be calculated from 31/7/2014.
and it will be paid from 25/1/2020. 25/1/2020.
Date of my release.
Date of
They want to say will not get two benefits.
Yes.
Your pension will be paid from 25/1,
yes,
Lot.
25/1/2020.
25/1/2020 and no recovery. That's all.
That is the ultimate.
For that will have to dictate a judgment.
Otherwise, his representation is otherwise. He said that you have already calculated the pension, you pay us.
benefit, maybe, but salary he has already enjoyed. Two benefits he cannot. Not it.
Third, Mr. R. Ali, learned counsel for the petitioner, also Mr. D. Nath, learned senior government
Standing counsel for the respondent.
standing counsel for the
APGCF.
FPCCF. Okay, standing counsel for FPCCF. The petitioner was initially engaged as a hire on temporary basis in the year 1983 under T then ASEB, Lakwa division. The date of birth, as per the date of birth entered into the service book of the petitioner, it is undisputed, isn't it, Mr. Ali? It is undisputed that in terms of the date of birth entered into the service book of the petitioner was to retire on attaining age of superannuation on 31/7/2014. Is that it?
No.
Huh?
But he claims that his date of birth, according to his date of birth, should be 61. He should be retired in 21.
20.
But after verification of the record, we have found that his date of birth is 1/7/1954. That he agrees, because the page 35, kindly see below, page 35 of the writ petition, annexure 10.
As per service record, my lord, date of retirement 31/8/2020.
31/7/2014, he
Okay,
retired.
where is your service? Okay, let us, if you dispute that, then you'll have to determine that.
Petitioner cannot dispute because I'm indicating.
Hmm.
Kindly come to
No,
page
no, he
35.
can dispute, we can reject it.
Well,
He can
correct,
dispute.
correct.
You cannot say that he cannot dispute, he
Well,
can dispute.
Well, this is the office order by which the benefits have been allowed to him, and this has been calculated considering the date of retirement of 31/7/2014, 6/8/2020, as what you've got.
Which page?
Annexure 10, page 35. Annexure 10, page 35 in the writ petition.
In the writ petition?
Yes.
Writ petition, annexure 8.
Annexure 10.
10. Okay.
The date of retirement has been mentioned as 31/7/2014, and in the writ petition he is praying that this order has to be implemented. So he has accepted this.
What is your case, Taylor?
My lord, they have given me retirement, my lord, by making an inquiry according to them, my lord. Although it is dispute, I accept the retirement. Retirement order, my lord, is 33.
No. What is your case basically? What is your prayer in the writ petition? We'll come to that. What do you want?
Page 37, my lord. The impugn order, my lord. Although they have sanctioned the pension, my lord, by giving effect the date of retirement, but they propose for recovery.
According to you, what is your date of birth and what should be your date of retirement and what is your proof? This is not a simple case of overstay according to you. This is not a case of overstay.
What?
What is your case?
My lord, date of birth recorded in service book, my lord. 31/8/2061.
Where do we get that? Show us the page.
The service book is not, my lord, with the petitioner, it is in the custody of the department.
Okay.
So, on the basis of their report, my lord, here.
No. How you substantiate your date of birth? On the basis of what your date was entered?
Page, my lord, 33. It's the order of retirement, my lord, given by the department. Page 33.
Fight between two brothers.
Lordship.
Brother retired long back. Brother, younger brother retired long back.
He's a whistle blower.
So retirement date given, my lord, 31/7/2004.
The second prayer,
Have you challenged their decision?
No, what?
So then that against penalty.
second prayer made in the reputation, case 7.
So this order dated 24/1/2020 is not under challenge.
No.
That their correction of your date of birth.
No.
Okay.
Lord.
So therefore 31/8 your date of birth is corrected as 1754
Lord.
on the basis of an inquiry.
Lord.
Since that inquiry validity of that inquiry is not under challenge, we are not endeavoring there.
Lord.
So therefore, in view of that, you ought to have retired on 31/7/2014. But since you continued, they after this inquiry on 24/1/2020, they have asked you to go on superannuation.
Lord.
Isn't it?
Lord.
Therefore, now question arises: what should be your date of retirement? Number one, and what should be your whether they are within their power to recover the amount. Okay.
Lord.
So they are saying that we are not recovering.
Lord.
And so far relating to your pension, it will start from 24/1/2020.
Lord.
It should be calculated as on 31/4/2014.
14.
But however, 31/7/2014 to 24/1/2020, you cannot have the salary and pension.
No.
So you are having the salary.
Lord.
So you will get pension from 24/1/2020.
Lord.
That's all.
That was sanctioned page 35. By
Yes.
giving page 35.
Okay.
By giving, my lord, date of retirement 31/7/2014.
Fine. So that is this. Do you challenge this
No.
order?
I
Then what is the dispute?
dispute, my lord, page 37.
Recovery.
Recover.
Only that much.
Lord.
Okay.
Possibly my learned friends cannot agree to them. Yes, I also cannot agree.
Okay. Take down. আর আলী লাগে এটা বললে না What is the judgment? Bihar judgment.
Rofik Masim, my lord.
No, not Rofik Masjid. Subsequent. Pandey Jagadishwar Prasad. If the judgment 2009 3 SCC 117. 2009 3 SCC 117.
Here that just including thinking.
Huh?
Here that included
Where?
from paragraph 12 on.
Where is that order? Asking you to go on retirement.
It's 30, yeah, 31.
Page 34. 33, 33, 33, 33. Yes.
What is your stand, Mr.?
But they have made an inquiry in the affidavit in opposition. Kindly come to page 71. This is the letter, verification letter by the principal of the school, and the school record is also annexed to it.
71.
Page 71, annexure 11, affidavit in opposition. The department has constituted a verification committee, inquiry committee. The inquiry committee has requested the principal. Principal has replied to this. With due respect, I beg to state that as per later mentioned above, presently there is no available evidence of book number so and so dated so and so related to duplicate school living certificate of Liaquat Ali. This duplicate certificate was given by him. However, for your convenience, according to the school record, I have found that Muhammad Liaquat Ali had been admitted in our school in class 4 in the year 1964. According to your school admission register, year 1964, his age on the date of admission, that is 3/2/1964, is found as 9 years 7 months today. And that's the register. Logic will find type copy you have given at page 73, original at page 70,
Original
at page 75, serial 75, serial number 39. Logic will find. This will be fourth, Liaquat Ali, son of Abed Ali, and Lordship will find 9 years, 7 months, 2 days. This is the age digit. This is a copy of the application. So on 64, he was 9 years, 7 months. We have accordingly calculated it is date of birth is 50.
How will you justify?
He is harping on
No,
the
no.
duplicate cert.
How will you justify, Mr. Ali, pass a judgment? Whatever we pass till it becomes precedent. How will you justify that this is not none other than by you? Even Pandey Jagadish Prasad also everywhere.
Page 30, my lord, it is
Until and unless they give a concession that we are not going to have a recovery without entering into the merit, if they are not saying recovery and this is a consensus, that can we dictate that order?
He is
I
praying,
think he
he is praying for implementation of the order of 6/8/2020.
so
Prayer
you
number two.
implement it.
Prayer number 2. Look,
That's all.
we can implement, but the thing is that only
Recovery.
recovery, Lordship, I have already started.
No, so recovery is suppose we under what circumstances we can say that don't recover. As a court of law, we'll have to give a reason.
Correct.
regarding recovery, Rofik must will cover, my lord, that grade 3, grade 4 post, my lord.
Even in the case of fraud.
The language, my lord, in the paragraph 18, my lord.
Paragraph.
In what circumstances, my lord?
Paragraph.
Paragraph 18, my lord. Part section, my lord. See that has made based on the decisions referred to herein above, we may as a ready reference summarize the following situation wherein recovery by employer would be impermissible.
Okay. The petitioner was serving as a turbine operator, grade 1 in APDCL, which is a grade 3 post,
Grade 4.
grade 4 post. Full stop. As per his service record, he was supposed to retire on
On 31/8/2021.
31/8 on
31/8/2021. As per
31/8 2021. Full stop. During his service period, his younger brother, who was also a turbine operator, who was also a grade 4 employee. Yes, Ali.
Sir.
He is also grade 4. Grade 4 employee lodged a complaint before the employer that the date of birth of the petitioner entered in the service record is incorrect. On the basis of such complaint, the department made an inquiry and finally came to a conclusion that the actual date of birth of the petitioner is 1/7/1954, and accordingly he was supposed to retire from the service on attaining the age of superannuation on 31/7/2014. 31/2014. 31/2014. Such determination was made by a communication, was intimated to the petitioner by a communication dated 24/1/2020, and he was asked to go on retirement with effect from retirement with effect from 1/8/2014. with effect from
31/7.
31/7/2014. 31/7/2014. Thereafter, an order was issued on 6/8/2020, whereby pension, committed value of pension, retirement gratuity, and family pension, etc. of the petitioner was computed. However, yet another order was passed by the respondent authorities on 24/12/2021, 24/12/2021, whereby the petitioner was asked to show cause why the salary drawn with effect from 31/7/2014 to 24/1/2020. আপনি 31/7/2014 or within bracket দিব actual date of retirement আৰু 24/1/2020 bracket দিব the date when the petitioner was released from service. Service. Full stop. The petitioner is aggrieved by the aforesaid order of recovery. Order of recovery. Full stop. Order of recovery. The prayer made in the petition, one of the prayer made in the petition, present writ petition, is implementation of the order dated 6/8/2020 within bracket annexure 10 of the writ petition. Mr. Nath, learned standing counsel for FPGCL, submits that they are
Our 10 is in paragraph 11, paragraph 15 of the
we will not go to all this. Just we are saying that they have no difficulty in implementing the order dated 6/8/2020. However, as the petitioner overstayed in service by manipulating record, therefore they may be allowed to recover the excess price. Full stop. Is not. Mr. Ali, relying on the decision of the state of Punjab and others versus Rafiq Masis within bracket Whitewasser reported in 2015 4 SCC 334 contends that the petitioner being a grade 4 employee, the recovery should not be made inasmuch as there is no specific finding of fraud or no specific finding that the petitioner has committed any fraud. Consider the matter in entirety. The fact remains that petitioner has rendered service with effect from 31/7/2014 to 24/1/2020. The fact also remains that the entire process of verification / enquiry was initiated on the basis of a complaint filed by the brother of the petitioner, not at the instances of the employer itself. Employer itself. It is also a fact that petitioner is a grade 4 employee, and therefore, considering the matter in entirety and in the given facts of the present case, more particularly the initiation of complaint at the behest of a third party, not by the employer, this court is of the view that recovery should not be allowed at this stage. Accordingly, it is provided that the petitioner be granted the pensionary benefit in terms of communication dated 6/8/2020 within bracket annexure 10 without insisting on any recovery from the salary paid with effect from 31/7/2014 to 24/1/2020.
Let me clarify, however, the pension will be from 25.
As per your document. You have decided that.
Okay. But
Full stop. It is needless to say that calculation of the pension of the petitioner is to be made taking his date of retirement to be 31/7/2014, and he will be entitled for payment of said pension determined with effect from 24/1/2020 as from 31/7/2014 to 24/1/2020. No recovery has been made and he has been paid salary.
well, subsequently, he was promoted to pump operator grade 2.
Pump operator grade 2, retired as pump operator grade 2. That is also grade 3 post. Grade 3 or grade 4? Grade 3.
It is
Okay. Pump
Joined with
operator grade 2, উপরতে 1 লিখেছিল, grade 2 and grade 4 of that grade 3. Okay, Moise,
joined as 4,
Okay.
retired as Avla.
Within some basic period,
they are ready to give you.
Let me give us 2 months time.
Okay. The entire exercise shall be carried out within a period of 2 months. From 3 months.
From the
We do not want another contempt.
yes, from the date of receipt of the copy.
From the date of receipt of a certificate copy of the order passed today to be furnished by the petitioner before the respondent number.
The respondent number 2, madam.
Respondent number
2.
Keep this, sir. Keep this document in the file. I will finalize it.
1.
Respondent number 1.
Look, Avla.
Claiming for a year salary as well as the retirement dues they have approached. Pursuant to during pendency of the petition lawsuit, pursuant to receipt of granted aid from the government lawsuit, the petitioner already the Restaurant Corporation has released the amount.
Release.
Yes, lawsuit. Lawsuit, I have given the instruction lawsuit.
We have given 8.26 crore, my lord, granting aid,
Okay.
so that they can at least, my lord.
But how far will you continue?
PL number 40 lawsuit. Petitioner case number 5.
Anandaram Kuli.
Yes, sir.
My lord, so it's started for
My lord, this is already, maybe my friend has not.
Released or what?
Yes, lawsuit.
Release,
Pursuant to
release.
this sanction order release.
All release, my lord.
All others, yes, sir.
Then what? The grievance of the writ petitioner is non-payment of
39%.
non-payment of arrears of salary / gratuity and other retirement benefit payable to the petitioner or payable to the petitioner. The petitioner was serving as watchman cum peon of the under the Assam Plains Tribe Development Corporation since 1984 and retired from service on 31/3/2022. Full stop. This court, under its order dated 29/6/2022, issued notice of motion. Full stop. Mr. Or who has submitted it?
My lord,
Mr. Kolita. Mr. Kolita appearing for the corporation
So that's one of 4.
and Mr. Dhor are appearing for respondent number
1 and 3.
1 and 7.
1 and 3.
1 and 3 submits that the submits that an amount of rupees
Serial number 40, my lord.
serial number 40. What is your statement, your amount in the writ petition? Any amount have you stated? Then submitted that an amount of rupees 11,39,800 24.00 has been sanctioned and released to the petitioner against the retiral due and arrears of salary.
My lord will find the right,
That is
right column, the
petition.
case number is there. Against each case number, we have released them.
11, 39, 821. In that view of the method, nothing survived to be adjudicated in the present, according to the petition stance, with a liberty to the petition to approach this court once again if the payment as stated has not been made or still some amount are due. With the approach it, the writ petition is admissible. Yes.
This case was there of those petitioners transferred to Tinsukia by order dated 21/7/2023. It was challenging regarding transfer lawsuit and against nullified transfer and impeded the response number 4 and 5. All have been temporarily transferred in different places. These are the orders. Again, promotion also got by 27.
I'm not getting anything.
You have no grievance.
No grievance remains, sir.
Tell that. Why should you
No grievance.
He has no grievance. That means
Okay.
That's it.
The learned counsel for the petitioner submits that the grievance of the petitioner has already been redressed. Accordingly, nothing survives in this writ petition. In view of such submission, writ petition is closed.
Apply.
Big time.
For respondent, reply.
For
very-
petitioner.
Okay. It says M. Dr. Learned counsel for the petitioner prays for and is granted 10 days time to file reply.
maybe.
Yes,
It is very small and simple.
that is the difficult. You start smaller, it will become bigger. Don't use that word. Yes.
The petitioners, they are entitled for, they are all retired PCCS and all. As per the Government of Assam Office Memorandum and Cabinet Decision, they are entitled for telephone and security assistance after their retirement. Initially, this facility was provided if the officer stayed in the state of Assam. Thereafter, another office memorandum was issued pursuant to Cabinet Decision. If any officer settles outside the state of Assam, then also he'll get this facility of telephone and security assistance. The petitioner, the petitioner number 1, he
Where
was
is ZAD? What is their stand?
they say that I'll just take your lordship to the office memorandum first.
Where is that?
Lordship will kindly come.
But he is not here.
So just for a glimpse, lordship will have it. Page Annexure P2, page 21 is the first office memorandum.
Page
21, Annexure P2. Subject is creation of the post of telephone and security assistant with fixed pay for retired chief secretary and equivalent rank. The Governor of Assam, after due consideration, is pleased to decide that the officers carrying from the post of chief secretary and equivalent rank who retired from Government of Assam and who are permanently settled within the state of Assam, initiate that was, may be provided with facility of the service
You have retired
as PCCF and HOP. Principal Chief, the Chief Secretary is
we'll have to first have
apex
a,
scale.
we'll have to have a determination that both are
equivalent.
equivalent.
They have given me this facility. Considering it to be equivalent, they have given me this
Now it's
facility. Yes, I engaged one
Manjula
okay,
Das.
Manjula Das.
Hmm.
She continued. For some reason, she did not want to continue. after her discontinuation, I engaged another person. When this new person I appointed, my lord, and I wrote to the government that I have engaged this person, kindly release the benefit. Government is sitting tight over the matter. Now in the affidavit they say that chief secretary post is exclusive. So PCCF how cannot be equated with. Lord, what about chief secretary and equivalent rank officer? Why you are forgetting this and equivalent rank officer? All are in
Because they are
apex.
having financial crisis, that's why they want to forget.
Assam government is or retired person.
Okay. None appeared for the CID, though Mr. Das is present for the affidavit. Pleadings are also exchanged. However, with the interest of justice, matter stands adjourned and be listed on
Immediate date.
19th of January.
Fine. Fine. Deeply.
Yes,
Some of the relief sought by this petition, my lord, were rejected by the Honorable Supreme Court in a petition filed by the similarly situated party.
Hmm.
The,
what was the issue here?
the termination of the foreigners tribunal members
Okay.
were appointed contesting.
Ah.
So
Now,
some of
what
the-
is your prayer in this report?
yeah, it is at 50.
Do you want to say nothing survived?
No, my lord, the prayer clause 4 and 5 survive.
Page,
Page 50,
page 50,
55.
clause, which prayer?
Last two prayer, 4 and 5, that relate to salary and allowance.
You want to say during that period, no salary has been paid.
No, my lord, 22, as per my instruction. Earlier, 2 months salaries were not paid, but later on those salaries were paid, but 22 days salaries still withheld, and there are allowances for car and other facilities which is admissible under the service condition
Hmm.
were not paid.
What is the stand? Affidavit file?
No affidavit.
Hmm. They are on 22 days salary and some park, some driver's allowance and all.
Yes.
You have, okay.
Have you indicated in the prayer? Yes.
No, what is the period?
Uh,
Specific, give us the period, which days, so that
So,
we can,
the petitioner served up to 14,
no,
15,
tell us for which 22 days, in which month?
October 2022,
October 2022, that's not a
September, part of September and October up to 15.
October 15. So 22 days will October 15 and there of September, which dates it will start? Okay, 22 days.
Yes,
Then,
22 days.
then
And then the allowances that is admissible under the service conditions for
We-
37 months. That will require
adjudication. At least that these are your entitlement, whether you have been paid, not paid. How can this court decide on?
I have filed represented those who are not on this issue
Difficult representation also difficult
at this stage
at this stage.
after their subsequent condition. And in
Okay,
fact,
they let them file an affidavit. Okay. The team would run it.
yeah, I'll-
Press for an drafted. 3 weeks on to file.
I'm a bit difficult.
Statement. Mr. Majumdar, what about 317? It is there or it has gone up there?
They have no, it has decided to go there because they are take it during a thing.
It should have been tested higher up.
They argued, and once he appears, he has to argue a point. He has argued. Now that
But
there
this
is
kind of judgment should be tested upstairs.
I'm that is bit, but here is because they also wanted because you got to the way. Who are the persons who are actually fighting?
But the issue was required
You're
to be
also-
tested.
Issues that were ultimately raised are very interesting and very. and then
Therefore, it should
submit-
be tested afterwards.
it is that they have been taken.
That is the bad part. Sad part.
No, that they have accepted that bit. That's the good part. State has accepted.
Sometimes that is a sad part. It should be tested higher.
Something of that, whether it is correct, some of the
Yes.
happen in some. I'm submitting on behalf of Mr. Thakur.
Hmm.
The petition is submitted for the first time taken. Let
Ah,
the
the-
response.
Yes.
Your Lordship, we have received basically taking some time with some letters.
To file an affidavit,
Yes,
whether it is permissible.
Yes.
Because these are not cases where we want instruction. You take your stand clear that whether this is permissible. If it is honorably acquitted, whether what will be that period? Under what authority or what provision can you take a decision which will be treated as that? Huh?
Yeah.
Yeah. So let them file an affidavit. Okay. All right. It's counted. Praise for and is granted. Give it time to file.
It is not important.
Okay, give a date. Give it. After chill, give a date. Is this matter on 30th?
Developed.
Obliged.
Yes.
Right, later.
Yes, Mr. Bora.
Now, your petitioner is retired from service on 31/2022, my lord.
Mm.
But they were not releasing the retirement benefit, my lord.
Pension also not yet.
Lordship, there is a issue, Lord.
My lord, but
Here,
then, my lord,
Lordship. Dear Lordship, the original service book
Hmm.
was collected by the petitioner himself from the office of the district elementary education officer on the pretext of furnishing it to the concerned authority for payment of pension. After collecting it from the office of the DO, he returned it himself for such a long time that on 28th of last month, December 28,
Hmm.
he has now realized that original service record is with him.
It is returned.
He now on 28, he has returned it to the office of the DO. And on second, yesterday, Lordship, he has furnished a confessional statement that
what?
Ajanite, it was
Yes.
written by
Now,
me.
forget about the Ojanite. Now, have you returned?
Now he has written as per him, but my instruction yet to receive. But he has furnished.
Have you returned?
Yes, sir. Please, the kindly see page 58.
Yes, 58.
This letter was issued by the District Elementary Education Officer, Opitu Sri Lokeshwar Bora, retired assistant teacher last night. And my lord, he himself is, as per instruction, just yes, please before. He stated that I have inadvertently stated that it's my book. So thereby he has taken. But regarding they file an affidavit, that this order, therefore you are requesting, there is some overstep. Copy to my lord Lokeshwar, I am the petitioner, my lord, retired assistant teacher. They are giving me by copy, so thereby I'm thinking that my copy.
So what to be done today?
But my lord, they file an affidavit.
They
Yes.
file affidavit.
Yes,
Yeah, we
their
have filed.
stand is very clear, my lord.
Hmm.
If I kindly see. They stated that,
In paragraph 7, Lordship, we have
yes,
There
that
are
is not
stand.
my lord. Well, please may kindly see page 66, paragraph 8. Because of that, petitioner is ought to be retired from service. My lord, on my lord,
Where?
my lord, page 66, para 8, my lord.
860.
6, para 8.
Huh.
That with regard to statement made in paragraph 22, the answer and respondent humbly begs that although the custodian of the service book is the drawing and disbursement officer, but annual increment pay petition is recorded jointly by the DDO and
No, suppose he has now given the original.
lawyer.
Now you proceed that.
Yes, my lord.
Lord,
That
that
is
is his law.
dispose of matter when the directed process is my fair.
Third, Mr. N. Bora, learned counsel for the. The petitioner retired from service on 31/3/2020 as assistant teacher of Santapur Sisa Pathar ME School. On attaining the age of Sisa Pathar ME School. According to the petitioner, he has not been paid his retirement due till date, and having no alternative, approached this court by filing the present petition. The respondent has taken a stand by filing affidavit that the original service book has been retained by the petitioner himself, and in absence of the original service book, the pension proposal could not be processed. Also, during the course of hearing, Mr.
Ian,
P.N. Sharma, learned standing counsel for elementary department, however, submits that in the meantime, recently the petitioner has
claimed to have,
petitioner
claimed to have.
uh,
He has given an undertaking that he has furnished now.
okay has okay no during the course of argument, Mr. N. Bora, learned counsel for the petitioner, submits that he has in the meantime, his client has in the meantime,
He has inadvertently
in the meantime, returned the original service book in as much as inadvertently he took the service book with him.
with him along with order dated 2019.
With him. Okay, with him. In view of the aforesaid fact, and as agreed to by the learned counsel for the parties, the present petition is disposed of with the direction to the respondent who will prepare the
Director,
District Elementary Education Officer will furnish it to the Director of Pension.
already furnished, that's fine.
Okay,
they
so the respondent authorities shall process the pension proposal of the petitioner, petition, and
But-
the same be completed within a period of
1 month.
what penalty possible,
Community Hospital, 2 months,
6 weeks,
6 weeks, 6 weeks.
within a period of 6 weeks from the date of receipt of a certified copy of this order. Certified copy of
This
this
is-
order to be furnished before the district elementary
Elementary.
education officer. Full stop. The petitioner shall cooperate with the department, cooperate with the employer department, and furnish and supply necessary documents as may be required for the pension.
Director.
No, we didn't all the respondents, but you will,
Respondent particularly direct.
no, because you will have to give the DO. DO will process it to the director. Now director will
period of
then send it to the
Director
and
of Pension.
accountant. This is the process. Therefore,
Stick to it, release along with
that's why I have said six.
releasing the pension or
Uh,
other service benefit.
That is what we have said.
That might be
The entire process should be completed within a period of 6 weeks from the date of receipt of a certified copy of this order to be furnished by the petitioner before the respondent number elementary education officer,
District Elementary Education Officer.
before the district elementary education officer, Vishwanath,
Respondent number
Not
3.
not Lakhimpur, within bracket respondent number.
What happened?
There is some problem. There is some problem. Again, there is some overtake. So thereby,
Then how can we decide? That's why we have said we have not commented anything. If you have overstayed, they will have to make a determination, recovery or something. Can we in apprehension, we can say that, so don't recover. We cannot say.
Well, but there is this order, that there is a specific is there, but retired person matter. Therefore,
But
you are
here we have doubt upon your client,
not a there.
serious doubt,
Lord.
because you have taken the service book.
No.
10%
Service
wrong
book,
there.
this is not my fault, my love. This may kindly see my letter. There is a copy to this order was along with copy.
Copy along with copy, but
Copy, the copy is in my, so thereby he has retained, my lord. He has no fault, my
Lord,
lord.
this is not simple, not that simple
Not
for a
simple,
school
Lord.
teacher. This is not that simple.
My instruction.
That you will obtain, you will take your original certificate. We do not know whether there is manipulation, there is no, we
Lord.
do not know, so we will not comment anything. And in the given fact, nothing to be survived, you say that original, they will process. In the process, suppose they want to recover, that will be different cause. We cannot in apprehension say that
There, I'm going to challenge it thereby, my lord. Last line, my
which
page 58.
Page?
Page 58.
Of your petition.
Yes, in my petition, page 58. Again, my lord, the retired person, unrated third grade food.
Page?
Page 58. With reference to the subject cited above, I have the honor to submit here with a copy of the BO Bipuria file under reference above, along with original service book of Sri Lokeshwar Bora, retired assistant from Satnapur, Santapur, so regarding overdue of salary as recorded in service book. But as per record, SSLC person his date of birth of 1/10/59. But as per record SSL30, his date of birth 1/10/59, and he had been retired on 31/10/2019.
Now, this order is not under challenge.
Yes, I am saying. In this regard, DO Bipuria has
So you file a
included,
detailed affidavit. Your affidavit is nothing.
Bora has been
Oh,
serving
Lord,
and therefore request kindly instruction for overdue of service Sri Lokeshwar Bora.
Lord, this was a forwarding letter
We
written
understand.
by the district elementary education
They
officer
give a-
to the director, along with the enclosing the original service record.
They
Now,
file
this
an
letter,
affidavit,
this letter, Lordship, the
he
petitioner
always
himself-
going to say some only service to service, but the detailed affidavit is there, madam. So thereby I'm saying.
Where is the detailed
Yes,
affidavit?
this affidavit is there.
Yeah.
Yes.
Where is the
Affidavit in page 64, madam. 64, sorry, 65.
Hmm.
That with regard to statement made in paragraph read petition is stated that DO Lakhimpur Bhailer informed that no record of corresponding in connection with all original record of the petitioner found in concern of father. He also stated the report of petitioner service was prepared by the office of the BPO B Puria and so and so. Next paragraph is stated that next paragraph 7
paragraph
and
7, Lordship.
7 regarding
Vital
service
Lordship.
book. And
Paragraph 7 is vital, Lordship.
that later along with paragraph 8.
Now, this letter,
Although the
forwarding letter,
custodian as there, although
this forwarding letter along with the service book on the pretext
why
of,
you given the service
on the
book to-
pretext of furnishing to the director of pension, he has collected. Lord.
and my lord, next, my lord, although the custodian of the service book is the drawing and dispersion of, but the annual increment fixed pay is recorded jointly DTO and concerned. It is totally wrong, my lord. As per my lord,
file a reply?
it's not simple, my lord.
No,
There is a specific, my lord. Service book cannot, my lord, prepared by the employee, my lord.
No,
Preparation
Mr.
and maintenance
Bora.
of service record.
Mr. Bora, what is your prayer? Let us come.
My prayer, my lord, is my kindly.
This is a premature decision if we go by all those things.
They taken a
Kindly come to paragraph 70.
yes, correct. Order director line letter should not be issued directly respond authority to release the pensionary and other retirement benefits due to the petitioner without any recovery from the final pension and retirement benefit of the petitioner. Further director responsibility not to recover any amount for the final pension.
How can we pass this order? Where is the
Yes.
proposal to recover?
Yes. So, my lord,
So, that order we can pass, or otherwise we'll ask them to file whether they are proposing to recover and what is the recovery. Tell us, give the detail. If you have manipulated, why should you interfere?
I think that I am not.
So they have not even done it. How can we on apprehension pass an order, do not recover? Because this repetition itself says you are aware of the all those things what happened.
No. That letter was overstated in paragraph in last
It
paragraph.
say that says that there may be
Therefore,
overdue
you
and
are
all.
requested
It give
to
us a
kindly
report.
information instruction for overdue of Sri Lokeshwar Bora.
So instruction, what whether he has What do we mean by instruction? If we say give the instruction regarding area salary, they may say there is no area salary, or they may say yes, there are area salary, but not 20 lakhs, it is 10 lakhs. This is the instruction. Your whole apprehension shows that that's why you have not commented on that. They may still go ahead with recovery. We are not saying.
My lord, that order may be therefore is necessary.
That is but we cannot on apprehension because this whole repetition is structured because your client very well knows that there should be a recovery. That's why very nicely.
Recovery cannot done by the gate.
We do not know. Suppose you have
Yes.
manipulated by taking the
No.
thing, then fraud is different. And he's a school teacher.
Yes.
Yes, next.
Problem.
Although in this repetition, my suspension allowance the retention has been kept detained since 3 years back.
Lordship, we have filed our affidavit matter, did not submit the required document to regularize his suspension period. If he yet to
Okay,
submit.
Add to. Okay, now.
Since then, the responsible were asked to appraise this court when they will pay my area salary. Therefore, another order was passed on 5/9/23, whereby the department was asked to regularize his regularize his regular his benefit. Leave period benefit. On the basis of that, the leave has already been sanctioned.
No, Lordship.
Leave was always sanctioned. This is the order. Yes. Leave has been always sanctioned.
You want only the arrears of salaries during period of suspension.
Yes.
Now, why he has
Subjections also not
Lordship, may kindly have a look, page 44, Annex 4 of my affidavit. Why we could not regularize his that period because he did not submit the required document. Lordship, page 44, Annex 4, the last paragraph. My lord,
have you filed a reply affidavit?
No, my lord.
Not
Yes.
yet.
No, my lord. I have already issued first order on 15/9/23. This court passed order on 15/9/23. On the basis
Honorable
of that,
Honorable High Court is referring.
my leave period will be sanctioned as per my papers just submitted before now.
After that, I have received instruction. After this honorable court order, I have received that. I have produced before this instruction, and the petitioner is supposed to take instruction whether he is submitting his documents or not.
Yes.
The order passed on 15/9/23 has not been committed to department by the concerned council.
I have
Yeah,
received,
thereafter, I just submitted this copy before the authority, and thereafter this leave has been sanctioned.
Okay, fine. Now,
Now there's nothing. My area still in now maybe please order to.
no, they are saying your area salary could not be regularized because defect in your medical certificate.
No, my lord, I know 3 years back medical certificate cannot be obtained. Therefore, this order of
Ah, that is
order.
also correct because
yes,
he is
sir.
saying that
cannot be obtained.
you a sanction against his available leave. Sanction it. Why you need a medical certificate? He will have to give a false medical certificate.
Yes, that's so correct. That there's observation on last occasion court has also discussed. He may produce some fake medical certificate.
Oh, he'll have to pay. See, question is this. He says, the court says that regularize in the existing leave. So it's not that he should be diseased. Here are medical leaves available. So adjust this against this period. That much only.
So you may kindly observe.
Why should you observe? You instruct your client and we are fixing it next Monday.
Just now I spoke to the legal officer, law officer of the department. He said he did not submit the documents so that we could not
No,
regularize.
you are given opinion. You are the
My lord,
standing
my
counsel.
lord, my lord.
From
In
where
fact-
will he give?
Yes,
Because the order is your departmental proceedings decision is that this period will be regularized against available leave.
leave.
So if there is leave, adjust that. Don't give him that leave. He will not get medical leave further because you will adjust it. Do that. Okay.
In fact, Lordship, we are on 2nd of January 2024, we have written the department for this area budget.
Area that he has already got.
Yes.
Oh no, you have leave has been sanctioned or what?
For area budget, we have written to the government.
Okay. Okay, Mr. MSMD Bora Learned Counsel for the respondent submits that the department has written sent proposal for payment of arrears of salary to the petitioner and only on 2nd of January 2024. Full stop. From the record, it is seen that the record, it is seen that the period of unauthorized absence from 23/8/2018 to 4/10/2018 were proposed to be regularized in the departmental proceeding by way of granting leave as applicable, subject to availability of leave is in credit and subject to submission of leave application. Full stop. Learned counsel for the petitioner submits that here are he is having leaves against he is having medical leave in his account and medical leave and earned leave in his account. However, at this distant date, he cannot produce a medical certificate. Therefore, this will be an impossible task for him to. Impossible task for him. This court is also of the prima facie view that as the employer has themselves decided that the unauthorized absence from 23/8/2018 to 4/10/2018 shall be regularized by of granting leave, therefore, in the aforesaid backdrop, if the leaves are available, that can be adjusted against the said period. At this stage, Mr. M.S. Bora submits that she will obtain instruction regarding availability of leave and adjustment of the said leave against the unauthorized absence. In view of accordingly, she prays for an adjournment. Prayer is allowed. List after.
No, my leave has already been granted to it. Already it is granted. Already it is granted as per order of this court. Passed on.
So if leave is granted, then they will pay arrears of salary.
Definitely.
Okay.
Already leave has been
Their
granted.
instruction
Now
won't have.
my subdivision was not paid for long years. My area was not paid till today. So now my subdivision is to dispose of the matter of as my
Now,
leave has
what is
already-
your prayer today?
as my
To dispose of with what
my
direction?
prayer is today, as per only point was there, that my leave was to be granted
Okay,
by
leave is granted.
already
Your
granted.
period is regularized.
Granted.
Now you are entered as area seller.
No, now my submission is to pay my area salary all. That is
Okay, so Angor order to take picture, then obtain it. We'll wait for this. She said that we have already sent proposal on 2nd of January. Should we dispose it of?
My lord?
She says that on 2nd of January, that is yesterday, they have sent a proposal for arrears of salary. Period of arrear salary 1416, you are Altafali, is not it?
Yes.
To 31/8/2018 and 19/2018 to 28/2/2022. So they have done their job. We have to either wait.
How long they will take? Already so many days already. But how? Minimum when I will get my.
That is your submission.
They
I
are
understand.
they are sending
Suppose
the
we
matter.
pass a direction today.
No, my lord, the respondents are sending the matter for area salary when it.
Now, what is the order you want? Dictate this. Will my steno will write. Yes.
My order is my matter may please be disclosed with the direction to development, giving a time, limited time. Then they will try. Without getting the order passed from the court,
That's
they
why
will
we
not try.
say
They will
that.
not try.
That's why we say that they have sent on 2nd of. So we'll obtain an instruction. We are fixing it after 2 weeks. On that they will see what is the status. If you want a disposal, that they will come.
All right.
উপর খেলে accordingly press করে নিতে পারে ঈশ্বর কিনি না লাগে প্রথম কি
Next day after 20.
After 20?
Because the 90 is my chance marriage.
Oh, then so even if we cannot fix on 20 or 24.
After 21 day.
After 25th.
After 20 in the up to 20.
We are fixing it on 25th.
20. Then the bond agreement.
25th.
Outline, sir.
We have that
I'll keep
instruction.
my instruction as a part of the record, the earlier instruction.
No, keep it. You keep it.
Outline, sir.
Yeah, right.
But petitioner has not been getting her family pension since 28 2022. Her husband expired in the year 2009.
Yes. We want a reason. Mr. Dev Chaudhary SDS submitted he will obtain instruction under what circumstances the communication dated 3/11/2020 has been issued by petitioner 2 and also obtain the instruction whether petitioner is entitled to pension as claim for and if so why such pension has not been granted.
I appear for 6 and 7, but I appear for 2 weeks. You have received the instruction.
Respondent number 11.
Here.
Yes, madam is here.
We have communicated that we are yet to receive it.
It's a pension. Let the person be here. We'll have instruction directly from him. We'll communicate to him directly. Let him communicate directly to us.
1 week after that.
After that. Okay, then instruct your client that after 1 week, they will have to come here and communicate us. We will not hear the lawyer. Yes, and what are others then? What is your stand?
So there not be
Of course.
for the fees. Coverage up to 8.
Then who, it is
I
whose
appeal
domain?
for
What is your stand?
Provident Fund.
Yes.
We have received instruction.
What is your instruction?
My lord,
What is your instruction?
my lord, there is no provision for stoppage of pension.
So then pay. Who is paying?
And
Who is paying?
11 has to.
Yes, 11. We want you there. You are the 11 newly implemented. Pension meter, madam.
Lordship, we have communicated with committee, but we have not received,
Okay.
like,
Okay.
for-
We are giving you time till when reopening after view. We are giving you time till 18th, and in the meantime, you take your stand. Vote. And if no communication, then they will have to come and communicate first. Directly. And we'll say that no payment for flight and all will be made by the department personnel. If we ask them to appear, because it's a pension, it should be sensitive. Madam, your name?
L. Davis.
Sorry. L. Devi, Learned Council representing respondent number 11. Submits that she may be granted a last chance. She submits that though she has written, though she had communicated with the respondent number 11. However, she is yet to receive any instruction. This court is the matter pertains to payment of family pension to the petition. Therefore, this court will expect an expeditious action on the part of the respondent number. Earlier also, matter will adjourn for earlier the matter will adjourn. Be that as it may, under prayer of Ms. Devi, matter stands adjourned and be listed on 18th of January 2024, on which date the Learned Council shall obtain instruction in terms of this court's order dated 7/6/2023. If no such instruction is forthcoming, this court may consider for personal appearance of the official concerned. Please take note.
Apply.
Suspension matter.
Hmm.
We have not reviewed nor has any started.
It's gone.
23 months.
Central government or state? It is beam suspension. When was arrested?
2/2/22.
Just note it down. Arrested on
2/2/22, Lord.
2/2/2022, page 16.
Subsequently confirmed by suspension order.
22/2. Then where is the suspension order?
It is at page 29, Lord.
Was put under suspension on 22/3/2022, page 29. In terms of Rule 6 of the Assam Services Discipline and Appeal Board 1964. No departmental proceeding has been initiated and no charge memo has been filed till date. Or filed.
One departmental proceeding has been received without any charge. After filing of the
Okay, that is it. No departmental proceeding was initiated within a period of 90 days. 90 days. And a notice of departmental proceeding was issued without any charge memo on
2010-2020.
2010 to 2023. Okay. And tell us, when have you intimated When have you released on bail?
45 was released on bail on 9/2/22.
Released on bail on 9/2/2022. When have you intimated?
45 filed 2 petitions for reinstatement after 25/11/22.
Intimated on 25/11/2022. Annexer
Annex F, Annexer E.
Annexer E, page 31. Or
And-
page 30.
Lordship will see the statement. This coming out of bail intimation is not clear, your lordship. Now, if it is deemed that this is a coming out, that
Lordship will produce my letter. Lordship. It is page 32.
Page
32.
lordship
Annexer
will
F.
also say
Again, page 34.
no, but where have you intimated that I was
Lordship,
released?
after filing of after the motion of this petition, page 42, Lord.
it, an additional affidavit.
Additional 1310.
Hmm.
1310.
Page?
Page 42, Lord.
The it stated that petitioner was released on bail on 9/2/2022, and thereafter he filed representation on
25/11/22.
25/11/2022, Annexer
F.
F,
14/6/23.
and thereafter on 14/6/2023, Annexer
G.
G. However, those two representations, there is no mention that petitioner was released on bail. But at the same time, the same communications were signed by the petitioner. That itself is easier on bail, signed by the petitioner. Subsequent to issuance of notice of motion in this case by this court, the petitioner again filed a representation on
13/10/23.
13/10/2023, where it is specifically stated that he has already been released on bail. 13/3, 13/10, 13/10, 13/11, 13/12, 13. Even from 13/11/2020, 2010, the almost 90 days is over.
11 January, I calculated 11
11, almost is nearing about 90 days. Okay, we'll correct it. Just I'm recording the dates. We have some details order. We'll just fit in the facts. Good stuff. It is an admitted position that no charge memo has been filed within the period of 90 days from the date of release of the from bail in that view of the matter. So satisfied, is directed that it can be reinstated, may transfer in any other department. So,
Lots of suspension order, if it is set aside from that day, like from the
no, that there is no meaning. We'll say that he will be reinstated.
Because if this
Since
set
not,
aside, then-
we'll say that since no review has been done, the suspension order has lost its validity. After 90 days, it will lost its validity, and accordingly, he shall be reinstated. Last contract order.
otherwise, if it is set aside,
No,
then
no,
it
will
will
not
have a-
reinstate. However, they will be at liberty to put the petitioner posted or transferred any places where it is good.
Highly obliged.
we can, that perhaps, whether it will be necessary, whether charge sheet can be issued, that liberty is always there. right?
Of course. That is of course. You can continue disposal.
I'm for it. Oh, one.
But you will get it after the order.
I'm for it.
He handy correspondent number.
One.
Highly obliged.
Sharma, sorry for troubling you all. I have got your
Both parties submitted.
submitted. In fact, I have started some work also. I'll close it today. Nothing to be. I have recorded everything.
Yes, sir.
And you have given that book. We'll deliver hopefully on 19th after.
Sir,
After.
Bihu packet.
After Bihu, we'll deliver the job. Okay.
Only my one submission.
Yes, yes. That's why I have kept it because we had long back and anything you may want to add.
My lord.
Because on last occasion you were also not keeping well.
Yes.
He replied. We even thought that we'll allow you. We will hear you again, but somehow then it was, yes.
Yes, my lord. In respect of the IA.
Hmm.
of
IA.
IA.
Hmm.
Of this
That maintainability issue.
maintenance.
Ah.
Only the maintenance.
Maintainability. Yeah.
Only the maintenance. IA. It has been admitted.
Huh?
It has been admitted by the division bench
Hmm.
of Mr. Justice Protestorship and Justice Sumekar. And it was also said at that time. The division.
IA number.
IA number my P671/2020. I have it enclosed in my sign of piece of enclosure 1.
It is there.
It is in this juncture, my lord, that when IA has been and also state at that time, then the case has been already started. Although the appeal was not admitted at the time, as because the respondent was not accepted the notice. It is directly issued to the notice to the department as well as to the police officer. Knowingly and deliberately not received the. Then my lord, in earlier occasion also, when the first appeal was been filed, earlier appeal, that is my lord, 33/2016. Then my respondent appeared, judgment has been given. And the judgment against the state judgment, who has passed the subdivisional, that is my lord, subordinate judge, autonomous authority. Same judge has been passed against this imputation.
Because it the earlier judgment, it was remanded with certain observations. Your case is that when it was sent, and that is those observations are not followed, then even if otherwise, if it is not maintainable also in this given facts, it will be maintainable because he has not complied with the judgment of a division bench. This is your one of your point. That is you wanted to add.
Yes.
Okay.
That is my at that time, when the case has been disposed of, my learned friend never
Raised this issue.
raised that
Because
is
it was adjudicated before the division bench and this issue was not raised.
This is my
The division bench transferred it to single bench.
No, that is it.
didn't separate.
That is because in view of the subsequent notification. Otherwise, this ought to have been in the division.
Division.
But now, in view of the notification, all these matters, except family courts, are sent to the single bench. So therefore, it is.
This point was raised before division bench. Subsequently, when transferred, then again we have to. And that IA, so far, my senior friend, IA has been already disposed of. That is the order. That may not be gone in.
Where is that IA disposal order?
Yes, 9th of February. I don't have a copy. I found in online, my lord. It was disposed of, and I was representing the respondent, my lord. Because,
Okay, that is regarding service.
Yes. Regarding service.
And you have raised the maintainability in the petition itself.
Yes.
in the petition.
Yes.
By way of an affidavit.
I have raised by way of an,
By way of an affidavit.
I have given a copy.
That is there.
And I've also submitted one synopsis.
I have got your synopsis. Okay, that is there. Brief note,
Yes.
legal point.
Yes.
In respect of regional marriage under customary court in the district of Dimar.
This only point three, only the customary. But in this respect, I am full and unspoken submission. The judicial committee is an integral part of judicial discipline, the cornerstone of judicial integrity. The subordinates never obey the division
bench.
But same judge has been passed.
Because your case is that if matter was remanded back to determine certain aspects of the matter, and those were not gone into. When those were not gone into, definitely an appeal will be maintainable because those were part of this decision.
I have one more submission matter. In your fairness, refer to the earlier division matter. But here
Review. Your case is review.
And
His case is review. Your case is that it was his case is after review it is merged with the This is your case.
Yes, and jurisdiction.
Now I recall everything. Everything is clear now.
Jurisdiction is already court has upheld. Sabune district court is original jurisdiction.
Justice must become.
Justice must prevail.
That is. But here, my lord, the same judge has been passed the order. Earlier judge, subordinate judge same, and present impugned to have been made.
Same.
Earlier he has paid for 70,000 alimony. Now he has paid
4 lakh.
4 lakh. But we have not taken.
That is lying
Without-
with the registry.
Without any head.
No,
Without any head. Without any
His
head.
case is that he has failed to exercise his
Exercise his
jurisdiction.
Yes.
And that too vested by this court in the division bench
Division.
judgment. So therefore, since he has failed to exercise his jurisdiction, when is a question of jurisdiction, appeal, this petition will be maintainable. And your case is that
Appeal provision is there.
appeal provision is there. Not only that, your case is that even subsequent to review order, it was merged and jurisdiction was upheld. So therefore, even if the court is having jurisdiction, there may be error of judgment. This can be cured by appellate court. This is your case.
Yes. And the appellate provision also I have referred.
That has been, the revision petition has been also passed by the division bench. Same thing.
No, not.
Yes.
Okay.
My lord, one more to add, my lord. That is, my lord, regarding my lord, it's in your fairness submitted some legal documents, notification along with written out. But that, my lord, it will be a power in my opinion, constructive responsibility. Already everything has been discussed in review petition.
No, that is there, but that will definitely help us. This what is the separation of judiciary? What is what?
But everything, your lordship, may I refer to the review petition, paragraph 4.7. This is already hesitated.
Where, which page? In which page?
Paragraph 4 of review petition 122 of our division.
No. Where do we get that?
I have given a certified copy of the review petition 122 of 2000. I checked morning.
You have given copy today?
No. Earlier, I have checked the record.
Okay. Review petition 122.
Yes. Paragraph 4.7, your lordship will see.
Paragraph 4?
Paragraph 4 of the review petition and paragraph 7. The notifications submitted by my senior pen is already discussed and taken into account. Paragraph 4 and 7. And paragraph 11 also. 7 is the notification in your fairness submitted, but already my lord taken into it. Each and every notice. How judiciary was separated from that is also. And paragraph 11, the All India Judges case.
What is the final determination in the review?
My lord, your lordship will see, my lord, is paragraph 18, my lord.
Paragraph 18?
Yeah. Paragraph 16 and 16, 17 and 18. Paragraph 16, 17 and 18. Again, they are taking one chance.
What is that original judgment?
They when
Remanding the method.
they when with the appeal memo.
Appeal.
Page 20, 30, matter 30.
30
of the math appeal. Paragraph 10 and 11. Because that point was not raised at all. Was disposed of my law immediately.
What was the direction? How to? Paragraph 7.
In review, my lord.
No, in the main page 32.
Main page 32, my lord, your lordship will see paragraph 11, my lord. 10, 11. That time we agreed that both the parties would be given.
What happened hereafter?
Hereafter, my lord, they, my lord, filed the review petition.
No, no, that I understand. Then it went to the
Subordinate.
then
Then, my lord, we filed an amended petition of our divorce petition.
then they
They
filed
filed a written.
then witnesses.
Witnesses, as per my lord, Rule 47, equity, justice, good conscience. Whatever procedure was there, but that was adopted. And both parties were.
Where is the judgment?
Present judgment, my lord.
Impugned judgment.
Yes, page 26.
Record has been called for in this episode.
No, because
Okay, so because
not admitted. The point was raised. But they came, my lord, after 6 months. They know their needed.
okay. Your case is that even after direction, the procedure spirit of CPC was not followed. Again, on the basis of Mojadar's statement and all, same decision was taken again.
And also one decision of
Hmm.
in respect what has been filed in here, my learned friend has filed to brief you
Hmm.
in respect of that in June one judgment has been given
Hmm.
that the matrimonial April 11/23
Hmm.
judgment and order is always in my in it. That is my lord. That is in that case that is a justice Honorable Justice A.K. Goyal and Mr. A.K. who has been and there is everything has been according to what is the admission of in the Mahasabha. More so, the due division petition is also admitted in respect of a case of the Mahasabha and Nagaland by the Honorable Justice I5. Yeah,
Just a minute.
that is my lord. That has been reviewed, has been allowed after discussion of all these things, my lord. That is my lord. In respect of shortcut So 7 rule 11, election of the and review petition is revision in case of the division that has been that we have been submitting. That is long time.
Just a minute.
Already been submitted, but in the third one.
Just a minute.
That is 2009 GLP
Just a minute. 2009
to GLP 80
2 GLP 830.
long.
I'm also referring to Registrar General.
That is my alignment thing detecting the heart Registrar General of that simple one person is we have sent all already have that is in everything has been discussed. Yeah, it is not.
Well done.
And in this respect also,
It was just a minute. 2009.
that is my lord. The revision petition under clause 6 of Assam High Court jurisdiction and District Council courts order in respect showing the referring any Supreme Court. That is justice is the
Yes.
and more so my lord, when the ordinance has been passed, but any date for the conciliation of if your if the conciliation both the parties in the High Court also, if they are not agreed, I have nothing to make. But no any conciliation has been given. It is the principle of the Marriage Act. No any order has been passed for the conciliation. Never they, only they have been as right as the Kaji Vichar. You do and go. You don't want, I go. Same mistake has been done after passing the division.
Judgment.
So how the justice should be prevailed if we, in the name of the administration of justice under 60. 60 is never said in the judgment is also the honorable division bench categorically and allowed us to file written statement as well as petition. They have filed a letter to the subordinate judge. On the basis of the letter, a case has been after that, the Honorable High Court has passed order, file a petition appropriate. Accordingly, they have filed. We have filed this statement, but they have decided. There is also conciliation and call for any quick and pass the order. That is our order, the subordinate justice order, at the difference both of them. Failure order and the impugn order.
Yes.
The same purpose.
Okay. Okay.
And under the evidence check, my God, it is a evidentiary value, but they have been appeared in earlier effect. Under section 123, my lord, and everything. And also further, 12, my lord, admission in respect of the admission. Order 12 of the CP. They must be obeyed. They have been admitted. The whole the cases in earlier occasion. Now they have come.
Amen. Yes, that's all.
The submission in the judgment, your lordship, is pottery. All everything has been.
Okay, on 19th we'll deliver.
Right.
Give me a minute. Just a minute. We have certain things we have already recorded. Somehow we could retrieve all those. We have asked to give a printout. Hopefully,
Otherwise, it is.
no, in fact, something we could retrieve, but we have, whatever we have to keep it. So just have asked them to give a printout. Sometimes it happens. What was the determination made in our earlier judgment? What was the mandate? Okay. Hmm. Third sheet page, second sheet.
Second, sir.
Hmm.
It is a page number 150.
Hmm. What kind of, suppose we allow this, what kind of relief you are expecting?
But that is what that's the age of the
Hmm.
next photo ask to say that it's
49. What is the age of retirement? He was working as
possible that
constable.
possible.
It is not armed. General.
Basically everything is up. That as per record with
Somehow we could retrieve a portion.
as per record whatever the
Hmm. Okay. Okay. Just we'll hear you on 19th on the point of not 19th. We'll hear you on 7th. 7th is a Saturday. Sunday. 6th is a Saturday. We'll conclude it on today's 3rd. 5th. Okay. It's just facts already I have recorded everything. Both of your facts we have recorded. Just give me a we may dictate your submission in the court itself on that date. Okay, not today. Or can we have it tomorrow? How many meters are there tomorrow? Because before Bihu, I want to finish it up and on your opinion to deliver it.
otherwise if I can argue that there's a point for
I have seen that. I've seen it. Okay, we'll take up this method tomorrow. Okay, and if possible, we'll try to dictate to the extent possible. You will go, just place your argument, we'll simultaneously record your all. Then we'll give our findings after. Okay. Please this method tomorrow for further hearing. That will that section 9 or something of CRPF Act and all this will just go to and the judgment you have relied on.
the charging section there.
Which is a minor penalty.
Minor.
Your whole case is it's a charging sections are minor penalty. So in that view of the method, it ought not
Ought not to have been both a major.
we'll give a try or otherwise we'll give a try tomorrow. That's it. You take everything. Please. Huh? Right. We try to send this. And it.
First side.
Huh? No, it will be over. We have only up to 14 part. So it will immediately after this method will go to your because there are some other part methods. Is also 2011.
30
Two part methods are there.
I am also
So we'll together we'll do these three methods will give preference. Then we'll go to other methods. Okay. Here are some methods. 16 and 17 these are series methods, is that it? 16 your method. Part third. PJ Mohan Panikar.
Yes.
That method.
That method.
Pay fixed.
There is also I have submitted.
That we may dictate on. We'll send these files. 15, 15, 16, 16 and 17. Okay.